and gentlemen, ladies and gentlemen, you are most welcome to the 15th edition of the Radical New Bar live press and public engagement, coming to you live from the Uganda Law Society Secretariat. It is a very, very distinguished honor to be in your presence, and we thank God for thus far that we have come. I am by the name Robert Benon Jirua. I am a Rule of Law and Litigation Officer in the Rule of Law Department. It is my singular honor to be the host of this show, and I'm going to take part in it as your moderator. We are very delighted to have you, and thank you so much for joining us on this very, very cold morning that, of course, is another of these days. Thank you so much. Today, our conversation comes to us at a very, very critical moment in Uganda's constitutional and democratic journey under the theme or two topics: public office and public trust, assessing accountability in Uganda's governance and the rule of law and the question of political prisoners. As always, this engagement is convened under the broader public interest mandate of the Uganda Law Society, the statutory bar association established under the Uganda Law Society Act, whose mandate, amongst others, is to assist the public in all matters touching and ancillary to the law, promoting access to justice, protecting constitutionalism and the rule of law, and ensuring that state power is exercised within the confines of legality, fairness, and accountability. Today's discussion is not merely political, it is rather constitutional, institutional, and moral. It is actually about the soul of governance in Uganda. The doctrine of public trust demands that every public office bearer exercises authority, not as personal privilege, but as a fiduciary obligation to the people. When the public confidence in institutions begins to erode, the legitimacy of governance itself is called into question. We are going to have a program that runs as follows. We're going to have the anthems sung, in which we shall be joined together with each other in the room. We shall thereafter receive an opening prayer from within the building, and thereafter we shall be listening in to welcome remarks from the CEO of the Uganda Law Society. Thereafter we shall delve into topic one that will be unpacked by one of our distinguished guests in the building. And thereafter, we shall delve into topic number 2, as was read. And thereafter, we shall get into a session of question and answer, after which we shall have closure. We're going to request that we stand up on our feet so that we can have our anthems sung. Thank you.
Mungu twaomba unilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tulilinde, tuajibike, tuimarike. umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you so much. Kindly be seated. We shall invite Miss Angom to lead us through the opening prayer. Thank you.
Thank you, our moderator. Good morning, everyone. Thank you for joining us, our speakers. Thank you for coming this morning. And thank you, our online audience. Let's humble ourselves for a word of prayer. Heavenly Father, we thank you for this day. We thank you for this opportune moment that you've given us to gather here. We pray that, Lord, as we're having these discussions, that you'll give us wisdoms, give us insight, give us knowledge, and help us to understand and to have meaningful conversations from this session. We pray, Lord, that will impact our communities and the society as a whole. We pray all this through Christ our Lord Jesus. We've prayed. Amen.
Thank you so much for that prayer. We bless the name of the Lord for thus far that we've come. This is the 15th edition. We don't take it lightly that God has brought us this far. And in our interactions with the public and the guest speakers, we thank God for life that we have. And we also pray for God's intervention in these deliberations. We would like again now to welcome the head rule of law, Ms. Afra Apio, who is going to be in the stage of the CEO to read her remarks as delivered on behalf of the CEO. Ms. Afra Apio, you're most welcome.
Thank you, Robert. Our distinguished guests today, Professor Wambutsia Ndebesa, Mr. Samuel Muizi Mulindwa, Mr. Alex Luganda, who is joining us online, Mr. Bayan Turinawe, the Governing Council, members of the Uganda Law Society joining us physically and online, members of the press, ladies and gentlemen, good morning. My name is Apio Afra. I'm the head rule of law. I bring you greetings from the CEO, Ms. Christina Worry, who is unable to be with us this morning owing to another equally important engagement. My chief task this morning is to read her opening remarks verbatim, and I shall proceed to do so. On behalf of the Uganda Law Society, I warmly welcome you to today's edition of Rnblive, weekly press and public engagement, a platform through which we continue to advance dialogue on matters of governance, constitutionalism, human rights, and the rule of law in Uganda. Rnblive was established as a space for candid, informed, and public-centered discussions on issues affecting our society and justice system. As Uganda Law Society, we believe that meaningful national conversations are essential to strengthening democratic accountability, protecting constitutional values, and ensuring that the law remains an instrument of justice for all citizens. Today's discussions come at an important time for the country. Questions surrounding accountability in public office, public confidence in governance institutions, and concerns regarding the administration of justice continue to dominate national discourse. At the same time, there remain growing conversations around political detention, prolonged criminal processes, alleged enforced disappearances, and the broader implications these issues have on the rule of law and human rights in Uganda. This morning, we shall engage with two timely topics. The first one is public office and public trust, assessing accountability in Uganda's governance, where we shall reflect on the principles of transparency, equal application of the law, institutional independence, and public confidence in accountability mechanisms. Secondly, we shall discuss the rule of law and the question of political prisoners, a conversation that seeks to examine concerns surrounding political detention, due process, access to justice, and the protection of fundamental rights and freedoms within Uganda's constitutional framework. We are privileged to be joined by distinguished guests and experts who will help unpack these issues from legal, governance, and policy perspectives. We thank them for accepting our invitation and for contributing their expertise to this important national dialogue. To all our viewers and participants, we encourage you to follow the discussion attentively and engage constructively as we collectively reflect on the state of governance, justice, and constitutionalism in the country. With these few remarks, I once again welcome you to Rnblive, and I look forward to an insightful and meaningful discussion. Thank you. Signed, Christina Worry, the CEO.
Thank you so much, Ms. Afarapio, for delivering that message from the CEO. We want to thank you so much, Madam CEO, for your kind remarks. We are always very, very certain of your welcome remarks, which are very warm and so welcoming. We thank you for your hospitality, and we pray that God bless you in your endeavors wherever you are, because we also know that you are watching us. Thank you so much once again. You have ably picked it up from the CEO's remarks, and of course it's easily visible given the recent developments in Uganda that have intensified public debate around accountability, transparency, and selective application of justice, including abuse of process and the shrinking confidence in the impartiality of state institutions. We have easily realized as well that in the recent years there has been sustained public scrutiny surrounding the leadership and expenditure, including from our public figures that are elected into elective offices, and we shall not also run away from the most recent, which has been on social media, involving the allegations linked to the office of the former Speaker of the 11th Parliament, which of course we don't need to mention so much because we are going to have a little bit of that discussion, but broadly speaking, we shall be talking about general accountability. And of course, at the same time, we are also continuing to realize and recognize difficult constitutional questions regarding prolonged detention, as the CEO has put it, and bail jurisprudence, in which we have noted and found that so many things have gone amiss in regard to respect for the rule of law, as we are going to be looking into certain particular cases that of course are both ongoing in the courts of law, but also without prejudice. We have had deep conversations with the speakers, and the guest speakers that we're talking about here are able to differentiate between what to speak about and not necessarily doing anything bad to the cases that are being spoken about here, because we are trying to look at specific cases, being that it is going to be rather a political question as well, because we are talking about political prisoners, including the detention of opposition figure Dr. Kizza Besigye, that has sparked local and international concern, particularly after legal disputes emerged about interpretation of mandatory bail timelines, as well as the transfer of civilian matters from military to civilian courts. We shall also be looking into a matter that is very much in the thicket of it, regarding Honorable Muhammad Muwanga Chivumbi, who is of course now outgoing, who he is a former member of parliament. We shall get that detail in clarity as we come back. But as we know, he is being arraigned before the Butambala Chief Magistrate's Court, and it has already generated a lot of debate on the same issues regarding pre-trial detention, due process, and the pace of investigations, especially after repeated remands and contested bail applications. Concerns have equally been raised regarding matters involving the deputy spokesperson of the National Unity Platform, that is Alex Waiswa-Mufumbiro, before the Kawempe Chief Magistrate's Court, with sections of the public questioning whether constitutional guarantees relating to liberty and mandatory bail are being applied uniformly and without political influence. Of course, there was a mention about that matter by one of the former justices of the Court of Appeal in his outgoing remarks, and of course it also raised a lot of public debate, and it leaves a lot to be questioned, and we are going to use that particular aspect or those particular cases to discuss today's topics, and we're hoping that you will be locked into the system so as to ensure access both to information and to justice in as far as the public is concerned. And indeed, very many questions are being asked, including, for example, what truly constitutes public trust in a constitutional democracy such as Uganda. To help us to break down and unpack these topics, we are going to be joined, as the protocol has already been broken down for us by the CEO. We are going to be joined by one of the speakers who is going to help us go through the first topic. And particularly, we are going to be having our first speaker, who is a senior lecturer at Makerere University College of Humanities and Social Sciences. He is widely recognized as a public intellectual and political critic. He has contributed to national debates through his work in academia, research, and media engagement. He is regularly invited as a panelist on political talk shows, policy roundtables, and academic fora, offering critical insights on political events and legislative developments. Ladies and gentlemen, please welcome with me Professor Mwambusa Ndebesa.
Thank you, moderator. Thank you, the management of Uganda Law Society. Thank you for inviting me to share these important issues with the public so that we can see how to take this country forward. I'm very humbled to be here today to share these important concerns of governance in this country. So we have this topic of political accountability, or accountability generally, but today what I want to share with you mainly is political accountability, not necessarily financial accountability, and in respect of corruption. So I invite you, those who are around and those who are watching us from somewhere, to pay attention to concepts that I'm going to enumerate today, because unless you understand what, for example, in the respect of corruption, if you want to have interventions against corruption, you must first understand what is corruption and how it is exercised. Because at times we tackle these things without understanding them. So I am going to engage in concepts, and I know most of the audience here is an intellectual audience, and therefore it is prudent that we engage concepts. When we are talking about political accountability, there are mainly three forms of political accountability. That is holding the executive mainly accountable. We have got vertical accountability. Vertical accountability refers to accountability of the citizens in general, of the masses in general. That is the vertical accountability. It can be exercised in many ways, talking, demonstrations, whatever, but mainly through elections to hold those in power accountable. That is vertical accountability. And then there is what is called horizontal accountability. Horizontal accountability is normally exercised through different arms of government or of the state holding each other accountable. The traditional ones, the conventional ones are the judiciary, the legislature, and the executive. But the executive has got many other forms of institutions that can hold each other accountable. Like you have the Ombudsman or the IGG's office, you have the CID, you have Human Rights Commission, you have Equal Opportunities Commission. Those can also exercise horizontal accountability within the executive. Now the third one is diagonal accountability. Diagonal accountability is this one which is exercised from civil society, like Uganda Law Society, like the media, like the academia, like the NGOs, like the cultural organizations, like the business associations. Those can exercise diagonal accountability. So we have three: diagonal accountability, horizontal accountability, and the vertical accountability. So I will at the end show whether these ones, there is space for these forms of accountability to be exercised. But now let me first look at this case study, if you want, or case to be talked about today, which is political accountability in respect of corruption. And quite often I have found that we don't understand corruption. And so interrogating this concept will help people to have intervention measures against this vice of corruption. And today I will concentrate on political corruption, which is least understood or not even understood at all. And in my opinion, political corruption is the mother of financial bureaucratic corruption. And so you cannot tackle corruption unless you understand the concept of political corruption. Quite often interventions against corruption, because they concentrate on bureaucratic, administrative, financial corruption, they are treating the symptoms rather than the real disease. And when you treat symptoms, definitely you will not eliminate the disease. Yes, I should not be understood to say that symptoms should not be addressed also. They should be addressed meanwhile looking for the underlying cause of the disease. In this case, we are using a metaphor. We are referring to corruption and political corruption. So, please pay attention to these concepts I am going to delineate. I invite you to do this one seriously by looking at the different types of corruption. I've already given you those types: political corruption and bureaucratic administrative corruption. But let me now go to the conventional, well-publicized, well-known corruption, which is financial, refers to things like bribery, paying somebody in order for a service; embezzlement, going to the public coffers and abusing your office and taking the money; or extortion, forcing somebody to pay you in order to get a service. That is extortion. Those are the conventional forms of corruption that people know about. And those ones treat symptoms. They don't go to the underlying challenges of abuse of office by public officers. There is even a definition by the World Bank and the Amnesty International, which I think is treating the question of corruption halfway. That corruption is defined as abusing public office for private gains. Yes, but not enough. That is half the truth. At times it is for public gain, for a section of public gain. Somebody goes and steals public funds and takes to his constituents, either to the church or distributes it to the people. That is for some sectional public gain. That is also corruption. But let me go to the different forms, different types, or what we call typology of political corruption. Political corruption. I invite you to understand political corruption. 1, favoritism. Favoritism has 2 types. One is nepotism. Nepotism is favoring close relatives, brother, sister, wife, husband, son, clanmate, tribesmate, in-laws. That is nepotism. And that's a form of political corruption, which distorts public resources, which distorts governance, which interferes with institutions. One form of favoritism, which is nepotism. I'm told it comes from the word nephew. That the priests, at one time, the clergy in Rome, used to produce children indirectly, even if they were, even at one time actually they were marrying, but even when they stopped them marrying, they would still, the clergy would still steal the institutional funds and give them to the nephews. So that's where nepotism comes from. So nepotism is a form of political corruption, which is part of favoritism. Next is cronism. Cronism. It is also favoritism, but favoring friends, club mates, whether you meet in Kampala Club or there is a club down here. What is it? Golf club? Something like that. Those you meet, or girls, old boys, associations, or party supporters. That is cronism. And when you favor those ones, you can't fight corruption. You can't fight financial corruption when there is that favoritism. I hope that is understood. Nepotism, cronism, and then patronage, which is also related. A patronage client relationships. You use public resources to create a clientele of political supporters. And those political supporters cannot be held accountable, neither can they hold you accountable, because you have developed a relationship of favoritism, of favoring each other. And that is another form of corruption, which is favoritism. In terms of, you favor people in terms of appointment, or appointments in the government offices, in licenses, in shielding them from arrests, in giving them information, because information is also a form of corruption, which people have not tackled. You are in a government, you hold a position of responsibility, and you give information to others, and you shield it from the others. When scholarships come, you inform your people to get them before others have got them. When there is oil somewhere discovered, they discover oil, you tell people that there is oil here, and the following day they will have their cows there. And somebody said that sometimes cows have sensors in their hooves. They will know where oil is. That's why they will stop. And the next time, the cows have developed now sensors in their hooves. So they will know, they will stay there, and when the oil is being explored, there will be compensation. When the road is going to pass somewhere, Tamaka road or whatever, or railway road or whatever, then you inform people that it is going to pass here. They construct a building, a small building. When it is being dismantled, they will pay you in billions. That is favoritism through either nepotism, cronyism, or patronage. Are we together? Yes. Another form of political corruption is called pork barreling. In simple terms, is budget corruption. You've heard of budget corruption. When they are making a budget, allocations are done favoritively. You just bribe people to take something in your constituency or this or that. You had those ones who were arrested. Unfortunately, again, they were pardoned. They were excused. They were forgiven. You know that. It is common. And one time, a certain Namuju, yes, that lady, the Honorable Namuju, in Rwengo, after the prison, she went and held a celebration. And the speaker, Honorable Among, and Honorable Chinjamatama were at that celebration. And they did mention that when you go and steal public resources, you abuse your office, get your hands into public resources and embezzle them, as long as you bring them to your community, it is okay. Did you hear it or you didn't hear it? And people clapped. And then anti-corruption institutions, the IGG, anti-corruption State House anti-corruption institutions, they didn't go there. They didn't ask those officers for having publicly, officially, formally declared that stealing public resources and sharing with your community is fine, is okay, is approvable. And you say you are fighting corruption. We are not serious. So there is pork barreling, which is budget corruption in terms of allocation. Another form of political corruption is called rogue rolling. This is buying votes. Dear listeners, can anybody tell me that we are going to fight corruption? We are not serious. During elections, let's start with the most important election, in my opinion. Elections to the Central Executive of the NRM Party, SEC, which is meeting tomorrow to make decisions for this country. Didn't you see corruption? Didn't you see aspirants buying voters? It was public knowledge. It was on radio. It was on TV. It was seen that those people were bribing people to vote them to be members of SEC. And that is a Central Executive Committee, the Politburo, that is going to decide the direction this country is going to take. And they went to those offices after they had bribed the population. This is what is called rogue rolling, buying votes, and you are going to a position of responsibility. And you go around telling people you are going to fight corruption? We are not serious. The Politburo, the Central Executive Committee, bribed their way into that position. And you go and look at those who are in the Central Executive Committee. Most of them, Not all of them, but most of them are exceedingly rich. They are thinkingly rich. They are rich people who bribed their way into those positions. It was common knowledge. Others took people over outside in hotels. Others were buying them here, right and left here in Kororo. We are near Kororo here. Come on. How will that central organ of the state, of government, fight corruption? So rogue rolling is buying votes is corruption. But everybody bought. Up to councillors, MPs, they bought votes, and those are going to be in charge of public affairs in this country. Another one is called rent seeking. Rent seeking. Those of you who are young and are even still in academia, note some of these types of corruption. Political corruption is called rent seeking. You seek rents. Tax evasion. You go to those in authority and you ask for special license to be favored. Hey, by the way, Wasarure, the former deputy IGG, has a very good concept which I like. He says that in Uganda, corruption is licensed. In Uganda, corruption is licensed. And when you lose favor with in politics, that license can be revoked. So the one of Anita Mong has been revoked. But before that, she had a license. She had a license. She was legally doing that. I mean, Parliament was, what did Agora do? Public display, called what? Exhibition. They exhibited. But as long as she had a license, nobody touched her until the license was revoked. So if you are involved in this public corruption, political corruption, be sure that you keep the license. Once it is revoked, you're in trouble. So, rent seeking, you can evade tax, you can have tax exemptions, you can have tenders and contracts. This is, most of the rich people in Uganda, not all, most of the rich people now are kayunjirizi. Yeah? They know how to pursue where there is a tender, where there is a contract. They are not wealth creators, they are wealth speculators. And they are seeking for rents. And when you don't know how to seek for rents, they say you are not smart. They are very smart people who know how to seek rents. And they get rents. But you must be well politically connected, and therefore political corruption. You must have some kind of gambanogu before you get the rent. So I had already talked about information leakage. That is to say, information leakage is a form of corruption. To know where there is going to be land compensation, where there is going to be oil discovered, where there is going to be uranium. We don't know the mineral map of Uganda very clearly. You one of these days, if you have a small plot of land, you will see somebody giving you 10 billion, and you will be happy not knowing that you will be given $1 trillion because there is uranium in that place. Why? Because for that person, he has the information or she has the information. For you, you don't have it. That information hoarding, information asymmetry, and then leaking it to those who are your clients is a form of corruption. So, what is the way forward now? That is in terms of, as I told you, we want to talk about, there are other forms of political corruption. I have not exhausted the list. If you want to pursue this one, I don't know whether Uganda Law Society have got a research department, and you want to pursue political corruption, I am ready to join you, and we delineate this form of corruption called political corruption, which is the mother of financial, monetary, bureaucratic corruption. As long as the source of corruption is politically connected, you will not address the other one because people will be having licenses. You can't deal with somebody. You won't do I am told that they are anti-corruption institutions, IGG, I don't know, CGE, Public Accounts Committee of Parliament, I don't know, President's Office, State House Anti-Corruption Committee, I don't know what. As long as the individual has a license and it is not yet revoked, you will not do much about that individual. Are you getting me? Once you are somebody is still licensed, you will not go very far. There is going to be cabinet, you are going to see. They are going to appoint people who are involved in Mabati to reappoint them. People went and took Mabati of Karamoja. Those who had license were pardoned. Those who didn't have, this Nanduta, I think she didn't have the license. But the others had license, and they have got off the hook, haven't they? There is a group of MPs who, some members of MPs and others who took money for cooperatives. You remember? Because they had a license, they went off the hook. They went for elections. They are back. They are going to be appointed in big positions. But if you are in Nanduto and you don't have a license, or if you are Anita Monga and they revoke your license, you will be in trouble. But before they revoke it, you are in business. So now let me conclude by looking at how can we intervention so that we have political accountability, so that those in positions of responsibility are accountable to the citizens, or accountable to each other in different horizontal ways, or are accountable to the civil society, the media, and NGOs. First of all, these people with licenses, you know, they go around in the villages even dishing out money. Yeah? So that they get some cheering. They are cheered. You know, those of you who are Christians, you know, there is a good Samaritan. Eh? These ones are bad Samaritans. We have got politicians who are bad Samaritans. Those who go and corrupt people during elections so that they are brought in power are bad Samaritans. So how can we handle these bad Samaritans who go around splashing money to the people and getting clients and those? So political space, there must be political space, and this political space must be respected by government. If government doesn't give people political space to fight corruption, government alone will not fight corruption. I'm not saying government is not making efforts here and there, but they have to give people political space, the citizens. So the civil society who actually helped to do whistleblowing, they think whistleblowing is going individually to say quietly, secretly, this one is embezzling. We want that public display. What did you call it? That exhibition. That exhibition is fighting corruption more than small whistleblowing, because it is dealing with institutional corruption, public corruption, political corruption. Now, the people who did that were charged. I think they are out on bail just. It was very shameful. And good enough, that group even included NRM people. NRM young people, the media people, the women people, the young people, they were instead arrested. So where is diagonal accountability? Where did it come from? If you whistleblow at that public level, open level, and you are arrested. I think government needs to give people space to expose some of these. The media, NTV, and Monitor have tried to be independent and expose some of these forms of corruption. What has happened? They have been banned from going to cover parliamentary proceedings, isn't it? So, how will you fight corruption when you are chasing away an anti-corruption crusade politically? Those are the ones who don't cover, I think, the president's rallies, They have been stopped from that. They are not given government tenders. So civil society is now being fought. Instead, they are being arrested. NGOs have been either closed or their accounts frozen. And yet these were the biggest whistleblowers because they do it at institutional public level. Now, as long as that political space for political accountability is not open, we are tinkering with the seams, at the seams. We are merely treating symptoms. We are not going at the source of the problem. Another political accountability horizontal now. Can we give space to Parliament? Parliament, some members of Parliament, the opposition, the committees, have raised some of these issues. Taking this example of Parliament, hasn't it been raised there before? Eh? These people, these commissioners who gave themselves money, there was a lot of shouting. Kosase did a lot of shouting. Some members of Parliament, even on the government side, raised these issues. I think this man who wants to stand for, I don't know whether he's in the race, raised it there, even quarreled with the speaker about the exhibition. They were ignored because the person still had the license. So, unless you open that space for horizontal accountability, then there won't be very much. The judiciary, the judicial officers, there is a certain judicial officer, a lady, I think, who was almost terminated somewhere in Ginger because she had raised some of these issues. They keep quiet, they are threatened. I think this Uganda, the justice, has just mentioned something after when he is leaving. But you know why he is doing that? Because he was intimidated to keep quiet. So the judiciary should also be given space. So should be Parliament. So should be the opposition and even government. You know, even the NRM MPs, the so-called rebels, when they tried to open to talk about these things, they were rebels and they have been sorted out. Now they are not going back to Parliament. So when you are a good debater in Parliament, the one who is fighting corruption at the political level, and you are sorted out meaning you are deliberately targeted not to come back to Parliament, then you are losing the cause of fighting corruption. Civil society, Uganda Law Society, the Radical New Bar, when you talk, they will take you to Rizira. They will threaten to take you to Rizira. And then fight corruption. So the question of political accountability here, at horizontal level, vertical level, and diagonal level, needs to be revisited. We need to revisit this one and give space to these whistleblowers. The whistleblowers I have in mind are not those who go secretly. I'm talking about those who go publicly. Publicly go and say there is something wrong here. And then the government should also equally respond appropriately. So, I am calling upon the anti-corruption institutions like the IGG's office to look at political corruption, favoritism, cronyism, vote buying, rent seeking, nepotism. There is this one, I think these days when we go for meetings, they normally say, declare your interests. Huh? Before assets, there is declaring interests. What is the other term? You declare your connected interest. Conflict of interest, exactly, that one. Conflict of interest. We have got a lot of conflict of interest. Is the IGG's office handling conflict of interest? You know, they are not doing that. That is why people employ their relatives. Either their relatives through nepotism or cronyism. If you go to most of these big offices, I don't know even whether this office, the executive director sits at the top. Normally, the executive directors sit at the last floor, isn't it? Yes. Now, if you don't know the tribe, the ethnic group of the CEO in a storage building, in a storage office, if you want to know, scientifically speaking, and you enter the building, just listen to the language the people at the floor are talking. Just keep listening. You will hear them short waving. Now the language they are short waving in, whether there's a sweeper, whether the bodyguard, whether the personal assistant, whether the receptionist, just listen. When you hear the language they are speaking, know that is the tribe of the person on the 8th floor or the 10th floor. Isn't it? Why? Because he has started, when he entered the office or she entered the office, she started appointing people from the same ethnic group. Now, are we fighting corruption? You go to these different offices, you go and do that research and hear the language they are speaking. They are short waving, those people. So, when you are talking about corruption, even this one, to me, this one of displaying these vehicles, I'm not saying we shouldn't display them. It is not the fundamental issue. That's not the fundamental issue. The fundamental corruption that distorts institutions, that distorts development, that distorts the governance of the country is political corruption. I beg to submit. Thank you for listening.
A bigger round of applause for that lecture. As the professor identified, he from the beginning assured us that he was going to lecture and that we should pay critical attention. Thank you so much, Professor, for your deliberations. And clearly, as we had prayed, the Lord has used you to disseminate information to both the people that are in the building, the lawyers, and the general public that are joining us online as well. And we are very delighted and humbled to receive these lectures because a lot of information is not within our purview. We can easily accept that you were specifically meant to come and teach us about the kinds of corruption, or rather accountability, moving from vertical, horizontal, and to diagonal, as you have already broken it down. And of course, the one that we are very much affected by is the one dealing with diagonal accountability, being that we are a civil society organization, and that doesn't, of course, stop us from being apart from these others. And we thank you also for helping us to define the different forms of corruption, which I imagine we have all understood. I want to imagine we are all hooked, because it was a very, very heartful discussion. We also want to re-acknowledge the types of political corruption: nepotism, cronyism, patronage, budget corruption, rogue rolling, and that, of course, also brought into our minds a certain aspect that has been discussed over the weekend to do with the Rolls Royce you didn't talk about, and in the local language it has been called the Rolls Royce. And we only imagine what happens when the license has been revoked. You have ably identified issues dealing with information leakage, which very many people have become a victim to, in regard to how people come buying your land, and as you say, 10 billion is paid and you're overly excited, and yet after 6 months the same individual will be applying for a compensation of over $1 trillion, which leaves a lot to be desired. But of course, most importantly is also the aspect of how we can intervene for purposes of accountability, or how we can sieve out these bad Samaritans that you've spoken about, because we are really discussing political corruption, and therefore majority of our discussions are going to surround around political figures. You've given us very, very deep recommendations. One that touches us very critically is your offer to support the Uganda Law Society under the research efforts that we are undertaking, and we can clearly assure you that under the Rule of Law Department, we have a research desk which is handled by one of our own, Miss Gwenny Patience, and we are very delighted that you have offered yourself to support us. We are therefore humbled to receive from the best. Mr. Professor, may you please be informed that at the Uganda Law Society, the CEO sits on the ground floor. She doesn't sit on the 11th floor because we are as humble as it comes, and we shall also use that opportunity to show that we are down to earth, and we have also been joined by a very important person in the governing council, and that is the treasurer, who is our one and only Mr. Arthur Isiko, Advocate Arthur Isiko, who has joined us in representation of the Governing Council. That is how humble we are over here. We have also been joined clearly by the Acting Secretary General of the Uganda Law Society, just next to you on your right. That is Advocate Babu Sali, who will be, these individuals will be speaking to us later on. We were also joined by Advocate Bayan Turinawe, who is a part of this speakers that are going to speak to us eventually for the next topic that of course is coming therein after. We shall also take heed of the empowerment that you've given us as a civil society, and of course all the others that have been affected by those that have had the licenses. You've clearly also evidenced that the Uganda Law Society has been very vocal in as far as corruption is concerned, especially that is meted by the government and the government officials. We have seen so much happening in which people that have been evidently spoken about being corrupt have also either been protected or given a cloth that cannot be touched, and they are eventually voted back, as you said, from the Politburo to the parliament to places that actually are supposed to be a sanctity of justice, a sanctity of sanity. We also want to note about the Justice Egonda Ntende, who is a friend of the Uganda Law Society. He has been a part of this series. He was our keynote speaker at the Sam Unjuba, the late, may his soul rest in peace, on that day that was celebrating him. He was a keynote speaker. He made very, very critical deliberations, but he also again identified with the Uganda Law Society in his final sitting and asked himself why we were not invited for that function. And yet those are some of the things that we keep asking ourselves about when we raise our voices and we are spoken out of these functions. Ladies and gentlemen, we thank you so much for being hooked to this function. We want to thank the professor for taking on and unpacking topic number 1 to its entirety, to leave us with more questions than answers that of course help us to reflect and imagine how better the country can be in as far as political accountability is concerned. And we would like very much to thank you, Professor, in whatever that you're doing. May you continue to be blessed by the Lord. Thank you for the work that you're doing. It cannot go without mention. We ask that you will continue to be with us, because this is not the first time you've come to us, because you have always honored our calls, and for us, we don't take it for granted. We are very, very delighted. May God bless you. Ladies and gentlemen, as we proceed, we would like to move into the next theme of the day, and we would also want to remind the members of the public and the guest speakers that today's session is dedicated specially to Arsenal supporters. That is a break. It's a very small commercial break. That is the reason that we are wearing this uniform today. Arsenal Jew, we finally won our trophy after 22 years of resilience, and would like to for that to sink in to everybody who is here. It is also another way to show resilience. It's another way to show that trusting the process, Professor, even when we are having challenges in the government about fighting corruption, we are trusting the process in which the government is trying to do as much as possible. But Arsenal explains it better, because there is always a victory after the 22 years. So the public is hereby requested to easily give a hug to any Arsenal supporter next to you so that we can be together in one accord. Ladies and gentlemen, that was a commercial break. We'd like to thank you so much for being with us. Those that are joining us online, thank you so much. We are moving into our second topic, and of course, it's not going to be any different because it has a lot of accountability to do with it. And we had earlier on mentioned circumstances under which we are going to be speaking about matters judicial, matters legal, especially in regard to political prisoners whose freedom and liberty has been questioned and has not come to them as would have been expected by the government. And of course, we are here as the Uganda Law Society to help to address some of these matters. Ladies and gentlemen, we would like to delve into the second topic, which is going to be something that deals with political prisoners, and we are going to be welcoming a former national legal advisor of the Democratic Party, NEC, that is the National Executive Committee, and currently a senior lawyer of the National Unity Platform, whereas he is also the former head of the human rights cluster of the Uganda Law Society that we always have amongst all the other smaller groups that we operate under, who help us to manage matters pertaining different aspects of the law, and this particularly with the human rights cluster. He is a former head of the human rights cluster. He is also currently the chairperson of the Valuation Court of Kampala capital city. Ladies and gentlemen, to help us to unpack the topic number 2, please welcome with me Advocate Samuel Muyizi Mulindwa.
Thank you for that introduction. I'll add that I'm also a former political prisoner. Yes, I've been in political prison, I think, more than 4 times since my days at Makerere, where I was the leader of the Uganda Young Democrats for some time, the leading political group in Makerere and the country at the time. My name is Samuel Muyizi Mulindwa, practicing with Alaka and company advocates. It's good that I'm here to discuss, you call it legal, but as you'll find as we proceed, it has ceased being a matter of law, but a matter of politics. You introduced it as a dialogue. I don't think it's a dialogue. You only dialogue with those who listen. We've become commentators in our country, especially on matters that are trying to assist the status quo to change. So we are perennial campaigners for change with those who are not willing to change. I restrain myself to the times when I know I'll not go to the academics like the professor. I thank you. It becomes rather hard for you to be academic after a professor has spoken. But I've been a beneficiary, just like many Ugandans, of having a few professors like him remain the professors we celebrate. There's a time when all our professors were taken up by government. They started speaking a different language, but that he has persisted, we don't take it for granted. One such professor was just my teacher, was recently lost a seat in Parliament. He taught me law, and when he starts speaking today, you wonder whether it's the same person that spoke before. So we are proud of you that you can continue to speak the same language since our days at campus and current. Through the RNB, I don't know how far we've gone in radicalizing the society in the fight for justice, because that is what I understand. we dedicated this time to trying to ensure that the public joins us, understands us in ensuring that we fight for the rule of law and justice in this country. We are talking at a time when we have a regime which is trying to protect their gains. In sync with this topic, I perceive it as a regime trying to protect their privilege, as RNB and us as lawyers try to push back, to fight for those who do not have the privilege. That includes the unprivileged in society and change-seeking forces, what some of you call the opposition. In discussing the rule of law and the question of political prisoners, as I stated, I don't find a lot of law to be discussed. I'd rather delve much on the politics in the political cases that we handle as private practitioners. But it's very significant. In the recent past, at least for the long that I've practiced, I crawled into private practice in 2005. So I'll speak to political prisoners since then. The time when with my colleagues, the Honorable Elias Lukwago Kale Baraka, were handling a matter for retired Colonel Dr. Kiza Besigye in the military court. That is my first case that launched me into having really all through the years quite some experience in handling political cases. And it's very significant. If you have to look at the jurisprudence of politically related matters, you'll find the years of 2000, there was a bit of 96 to 2001. At the time, I was the National Legal Advisor of the Democratic Party and leader of the UID. We had a bit of political prisoners at the time, but it heightened more. Again, you look at the significant years of 2005, you look at 2011, you'll find cases of 2016, and that was mainly dominated by political prisoners of the FDC. Key being retired Colonel Dr. Kiza Besigye. That is where you'll find a lot of jurisprudence, especially on matters of bail. You'll not find a lawyer now handling a serious case on bail failing to cite retired Colonel Dr. Kiza Besigye. We got a lot of jurisprudence there because of the numerous bail applications that we handled. Since then, I'll tell you that the practice for political prisoners has been mainly bail. I do not remember a case which was prosecuted by the state to its logical conclusion, at least not those that we've handled. And this is not to state that the case should be eager to prosecute and convict on directions of the state. Most recently, when we were handling the last bail application of retired Colonel Dr. Kiza Besigye, the one on mandatory bail, there's a statement which came from Entebbe, or Nakasero Entebbe, and questioning the DPP and state attorneys why they have never convicted retired Colonel Dr. Kiza Besigye. And since then, we've seen all rules of procedure in the High Court being overturned. We've seen the law not at work. We've seen a case where anyone who went to law school and LDC will really not feel comfortable being defense counsel. That's the ongoing case of retired Colonel Dr. Kizza Besigye. It is a 2024 case where all rules pertaining to extradition, the rules of procedure in criminal matters have all been flouted. And it is such a matter which has even overturned the previous good jurisprudence that we had gotten out of the famous bail applications or bail decisions of retired Colonel Dr. Kizza Besigye. But among these significant years again, you'll find that since the Honorable Robert Kyagulanyi Ssentamu, the president of the National Unity Platform, since he came to the podium in 2018, we again saw another big number of political cases. So it has kept on shifting. Political prisoners for the DP at a given point in time, to the FDC, and now we have hordes of numbers of political prisoners from the National Unity Platform, especially between 2018, the Arua issue. Of course, the NUP was not in place, but those related to since the Honorable Kyagulanyi came on the political scene. And between 2021 and 2026, we have very big numbers, more than ever before, political prisoners of the NUP. And as I've stated, along the way, we had a court-martial, which was a military court, which was dominated by political cases rather than cases of serving officers. I think it's the reason, as lawyers and the courts fought so hard to ensure that at least the law is practiced in the courts of law and not in the military tribunals. Of course, we did a lot there, and the courts did their part. But again, the executive strong arm was very fast using letters of direction to again take us back. It is such dispensation where we've seen matters having been transferred from the military court, purportedly, to the high court, but without files. As we talk about political prisoners, we have political prisoners who have files, and we have political prisoners actually who do not have files. So we've followed up on matters of files which were being transferred from the military court martial to the high court. We do not see such files. So we are faced with a situation where we have political prisoners that we as lawyers have the locus, have the means of defending. But let's also remember that we have people in prison who do not have any trace of files. People who do not have remand orders from courts of law. People who cannot be traced as we attempt to protect them, especially the people who were arrested in the election. If you note, all the years that I've highlighted are election years or at the eve of elections. This is what clearly tells you that all these matters are political in nature. They are political cases. We get a lot of such in the election years, the significant ones that I've highlighted. So the most critical challenge we have is at least that group of 2021 who were arrested, especially members of the NUP. We have the machetes and group. As a law society, we need to handle this issue. It is very critical that you can have a client, a political prisoner, who you go to the High Court. The High Court will tell you we cannot proceed with this matter because there is no file. for us to proceed. Even if we are to give relief to your client, we have no file before us. And this again arises out of, again, some of our members, senior members of the bar, misinterpreting the law to suit the regime. This arose out of a misinterpretation by the current sitting Attorney General on what the implication of the decision outlawing the court-martial was. That's how you ended up seeing people who ought not to have been in prison, staying in prison without remand orders from courts of law. So this is one of the critical areas we need to discuss as the law society. How do you deal with such a situation where the Supreme Court said probably matters should be transferred? You go to the High Court, there are no files transferred, the DPP is not doing anything about it, and these are matters of rights. You go to the laws pertaining to rights, the High Court looks the other way. I think we need a concerted effort if we are to speak about what we can do as a society to assist. What would you do as a private practitioner faced with a decision of the High Court, which does not even want to listen, even with the fact that the High Court is aware? It is an undisputed fact that there's a person who is detained in prison unlawfully, a person who is detained without trace of file, and the High Court chooses not to give audience. I think we need to do something in that area. Of course, speaking before you, the case study that had been charged with discussing with you is the matter of MKM, not the other MK. MKM is Mwanga Chivumbi Mohammed, as one of the cases that I'm handling with my colleagues, Elias Lukwago and the Honorable Medad Segona. And if you realize, we are the same people that have been in these cases. And you'll also note, as a law society, those who are following, that you will find that very key figures, several senior practitioners have since decided not to continue with this practice, because as we handle political cases, as I stated, it is the politics of the case. Even when we are discussing, it is no longer a matter of us discussing the law. We are always discussing strategy on ensuring that we have our persons released, as the state also discusses strategy on keeping people behind bars, even without lawful charges. So if faced with such a situation, so many lawyers who feel that whatever they do, however good a submission they make, it will not matter. But the politics, several practitioners have decided really to stop practicing in these areas, leave alone the challenges we face as the private practitioners, finding our offices broken into, finding spies always following us, finding our families being threatened. So is the practice of a private practitioner in such cases. A case in hand, you saw in the papers, my senior colleague, Kale Baraka, you find a CDF. Where does the CDF have business dealing with an investigation into a criminal matter, that he can even threaten that Kale Baraka would be arrested for merely representing a client? It says a lot. Of course, our experience is you can practice any law, but not that threatens or seeks to threaten the powers that be. So it is the politics of the political cases that we handle that we should focus on. Look at the challenges that we undergo, especially to any lawyer. If the law is not applied, if it is the politics, should we become politicians in courts of law? And I'll tell you, I think that is why some of us subscribe to the radical new bar approach, because you cannot continue in a situation where the judges will not listen, and you behave and submit as usual, it will be very unreasonable for you to remain as reasonable as we expected to be, with decorum expected of an advocate faced with such a challenge, where bail is granted selectively. I'll give an example. We had hundreds, mentioned thousands of political prisoners in the 2026 election period. You'll find yourself, one lawyer having to bail out hundreds of prisoners in a day. I remember a situation where I went to Wakiso court, and actually the prisons were in charge of all court premises because the cell was so full that they had to use that quadrangle. For those of you who know the High Court at Wakiso, the green belt had to be a prison, and prison said, no, now when you cross here, it's prisons in charge. This is a detention facility. We've seen this happen. We've seen times where you lose count. You get hundreds from Masaka, hundreds from Jinja, hundreds in Wakiso, hundreds in Barara, all on your desk, on the legal desk of a political party, which even does not have facility, or is not facilitated to ensure that you represent. And when you go to courts, it is not the law again. Even when in our favor, it's not the law which is being applied. It's not procedure being applied, but the politics on phases. You imagine a judicial officer telling you as counsel that, you know, these people, some of them don't even waste your time. These will only be released after the election on the 15th. Then after the 15th, no, this cluster of people will be released after swearing in. Then this cluster of people, that one we are not certain. And that's the kind of discussions we always have with judicial officers. You face a judicial officer who, after denying bail, you go behind in their offices and you find them so emotional about the decision that they made. You find judicial officers no longer comfortable practicing or being judicial officers. So we are all under state capture. The judiciary, especially in this practice of political cases, is not the one that we can discuss as lawyers. It is one which calls for further action of trying to radicalize the people, because we cannot do this fight alone. Trying to ensure that the people participate fully in ensuring that we have change of the status quo. Of course, leave alone the capture of the judiciary as a whole. You find a very strong executive arm putting a very heavy shoulder on the judicial arm of government. So these and so many are issues that I can put at the fore for your discussion. A lawyer faced with a matter which has no statements, not of a complainant, not of an accused person or accused persons. The case of Mwanga Kivumbi is such one other case that you'll not find, there is no statement whatsoever on the case preferred or charge preferred against him on file. He was bundled up with other accused persons, albeit at the start who were said to be and others at large, but then picked from another file because they had already been remanded by a court. So now the state is faced with a rather funny situation that Mwanga Kivumbi has no statement because the interrogation was primarily on a different charge. They were talking about malicious damage, incitement at the division. So he went all the way together with us as counsel, faced with that direction. But in between Chira division and the court in Butambala, then there came a charge on which they did not have any background, but for a decision that should be the charge, that should be the holding charge, because they were certain who were ready to apply for bail in Butambala. And it is such charges that they have used to keep people on remand, because political prisoners are serving sentences on remand. We have no convictions, but the time you spend on remand is the sentence that you serve. So you find yourself in Butambala. They could not have a file with co-accused persons because there were none anyway, if you looked at the statement of the charge. Then they chose to bundle young people onto his file. People who are already in prison, detained on another charge, a charge of malicious damage. So you transfer accused persons who are on a file already sanctioned for a different charge onto a treason charge. So the state finds itself in such a situation that it cannot transfer the statements made by those who had been previously charged on incitement. They cannot transfer those statements onto the new file. So they are in a situation, and they cannot have a statement from the Honorable Mwanga Chivumbi. We have files of political prisoners where you only find statements of police, only on file, with no complaints whatsoever. That's the reason even committing these people to the High Court becomes such a daunting exercise. Sometimes we pity our colleagues who are representing the state because they always have nothing on file. But we find ourselves in a situation that, what do you do? For example, you find a file where you find 16-year-olds on a capital charge, without any background. That also goes back to the justice, law and order sector generally. It is very clear that political prisoners are not even screened. It is a choice on how. I found myself in Mengo with a file with a person who is clearly insane. They just threw people in court in Mengo, and apparently one of them came. They could not even answer to the charge, and it was very apparent. They had picked a vagabond in Natete on the streets because it was a street swoop through police. Handwritten charge sheets. A handwritten charge sheet where you cannot even discern the statement of the offense, the charge and the persons, and they're just being taken through the system. You find someone who is clearly insane finding themselves in court. You find young people, 16, 18, on a charge sheet where they are being presented as adults. You find a charge sheet, for example, in Mengo. Those who are there, where you find pregnant people who cannot even stand detention. And that is the screening we find ourselves in. The court saying, okay, we can feel a bit of compassion for those ones we shall release even without sureties. So you find the discrimination, even as practitioners are participating in the discrimination on who is entitled to immediate release and not, as if it's a conspiracy on who can be released now and not tomorrow. But what do you do at the end of the day if you want your client or a person you're representing, an indigent, out of prison? So it is the politics in political cases. It is not the law at work. If it was the law, probably would have seen a case being prosecuted to its logical conclusion. So that's the discussion. That's what I can throw on table as my experience as a political prisoner, as I've told you, and a lawyer who has practiced matters political in nature for the last 20 years. I thank you for having given me this chance to throw this presentation for further discussion of those before us. I thank you, colleagues.
Wow, thank you so much. Advocate Samuel Muyizi Mulindwa, very calm in voice, very reserved in statements, but very biting in aspects to do with especially your history and attachment to the topic, because it is also personal for you to have been a former political prisoner, but also from your days back as you interacted with the Uganda Young Democrats. That was a very, very strong outfit by the Democratic Party that made a lot of strides, gave birth to very many of you, including, as you said, your colleague, the former mayor of Kampala City, Honorable Elias Lukwago. We are thanking you so much for bringing us to light, especially in regard to how we have had to separate the aspect of whether it is the law at practice or politics at play. Because if you can ably state that if it were really the law, then some of these cases should have been brought to their logical conclusion, especially the one that you, of course, identified with for Dr. Kanokiza Besige, which has been running for as long as we can remember, and yet it sounded a very simple thing, especially when matters had been concluded as far as the Supreme Court ruling that there should be a transfer of these matters, and for there to be nothing is very, very, very critical. And of course, we identify with the statement you made regarding the regime trying to mostly protect the privileges, whereas they claim to be protecting the gains, and the gains is being touted to be the development that has come forth. But we're asking ourselves, has there been any notable development under the rule of law? Because the topic today is rule of law, the question of political prisoners. You have also called us as the Uganda Law Society, especially the that you subscribe to the Radical New Bar, which we appreciate you for, because you have continued to walk with us. On the 11th day of February, we were together. I was privileged to attend court with you, and where you were representing the one of the contestants who participated in the woman MP race, that was Rose Nalboa, who, of course, we had to attend before the judge who was moved from Kampala to Masaka. For that particular purpose, it was a judicial review that we failed to understand, and I was privileged to be under your wings. I have learned so much from you. You also were in the participation and appearance with our honorable council member from the Central, that is Advocate Alexander Lule, who that time, and it has been a very, very interesting journey learning under you, especially given your history beginning from 2005. That was your first matter that I think speaks to you, which speaks to your heart, Dr. Kiza Besige. Still, the jurisprudence that you've given us is really a lecture, whereas you could not speak academic after the professor. You have also opened our minds to the fact that really the truth is, for us, the younger lawyers, quoting and citing matters to do with Dr. Kiza Besige in regard to bail. And we have not yet cited matters beyond that. The cited been really to do with bail applications, and which, of course, leaves a lot to be desired. But specifically, Council, thank you so much for highlighting the matter of MKM, which, of course, was really the other reason that we had requested your wisdom. That is Honorable Mwanga Chivumbi Mohammed, who is being arraigned before the Butambala Chief Magistrates. I have also been a privileged lawyer to work under your wings. We were there together, trying as much as possible to operate under that perspective. We, particularly as the Uganda Law Society, were part of the defense team. The Vice President, Advocate Anthony Asimwe, of course, under the guidance of Senior Counsel Isaac Semakade, had earlier on given us the privilege to go and defend those 24 individuals who these of Advocate Samuel Muyizi came and phoned us already trying to apply for bail. They had been here, for your information. We had collected the bail the documents, the bail application documents from all the 24 inmates. On the day that we went to apply for bail, we found that the charge sheet had been amended, and all of a sudden we realized that Honorable Mwanga Chivumbi Muhammad had been added to our charge. And of course, in his political stature, we had to be I think you can imagine, say, sunk into his case, for which we had no disclosure. We didn't have documents, we didn't have statements. We were there with Honorable Segona. We had Honorable Arias Lukwago, the Lord Mayor, and Mr. Kakande, Advocate Kakande, and a number of other lawyers who had to come out of their, not comfort zone, we can't say, because they are really those that are trying so much to fight for the people. Your call to us to radicalize the society in ways that bring out the truth, in ways that speak truth to power, is very important, especially in regard to these aspects going on. We've also experienced the bail applications that you spoke about in different districts, Masaka, Jinja, Mbarara, Gulu, Kabale. You mentioned it, all the political prisoners that were arraigned before were only needed in court up to the time of getting bail. So that has been very critical, and would like to thank you for discussing that topic and bringing the members of the society and the general public to the know of what it means to be in this kind of place. And we continue to ask that God will bless you, because these are very rough times. We wonder and pity how you go through them, but you have been relentless, like Arsenal, that was relentless for 22 years. We want to identify with you, because from 2005 you've still been fighting. Jurisprudence has been mixed up between those years that you identified, 1996 to 2002 to 3. Then there was 2018, 2019 to 2026, where we are right now. The jurisprudence has shifted from Dr. Kiza Besige now to the NUP political prisoners, especially, of course, the president that you mentioned about, who we wish well in his endeavors, obviously, because these are some of the few figures we are talking about that are trying as much as possible to fight for the common cause, and let alone realize that the rule of law is practiced to its entirety. Thank you so much, Advocate Samuel Muyizi. I know we called you in short notice, and you've been a very busy man. Last week you were very busy with the Honorable Mwanga Chivumbi case. That is why we had to postpone this function to today after speaking to you. And for us, it means the world for you to come, give us some of your time, and help us to understand what the rule of law and political prisoners is supposed to mean, and how better to understand the matter. Thank you so much, gentlemen. That was a very particular case deriving from the Butambala Chief Magistrate. We are still hooked to the same topic. We would like to move forth to one of the other subtopics in regard to these political prisoners. In regard to the political prisoners topic, and we have chosen to hear from the horse's mouth by interacting with advocates who are actually in the thicket of it, the advocates who are in representation. Maybe for you to know, the Uganda Law Society has also been working in tandem with these lawyers, because at the end of the day, it is about the rule of law. And the president of the Uganda Law Society, we all know he's an ardent person regarding the rule of law being practiced to its entirety. So we identify with these individuals because we have the same cause, the same reasoning, and we want the same objective for these individuals. We, rather the public itself, we would like to thank you. We are going to move straight away to hear into the next guest speaker, who should be joining us online. I would like to know from the IT department if our advocate is able to join us, please, so that we to introduce you. If it is okay, kindly signal us if you are available, so that we can easily interact with you. Please, are you there, please, Mr. Alex?
Yes, I'm there, my brother.
Okay, thank you so much, Mr. Alex. We are going to be receiving you to speak into the topic that we know we had shared with you, that you are aware of. And very, very briefly, we have with us Advocate Alex Luganda, who is not new to the Radical New Bar. He is a friend, and he's coming from far, especially with his relationship with the president of the Uganda Law Society. He has a very, very deep portfolio, and he is, among other things, a current member of the International Federation of the Uganda Red Cross. I'm sorry. Please kindly mute before I can allow you come back in. Sorry, we're getting some feedback from you being on. Just a minute, Alex, please. He is also a commissioner, Ginger City Land Board, and he is a board member, governing board, Uganda Red Cross Society. He's also the current Minister of Justice and Constitutional Affairs in the Busoga Kingdom, and as well a member of the Busoga Kingdom Return of Ebyaife Negotiation Committee. I hope I have mentioned it well. You will help me to correct it if any. My apologies. But you're also a member of the Busoga Luchiko and Chairman Legal Committee, and also a board member of the Sam's Food Industries Limited, with a few others. Of course, he is an OB of St. Mary's Chitende SS. But also, while we are looking into his history, he has had a very, very long spell in leadership. He was the guild speaker of Makerere University Students Guild, where he was also a speaker to myself. He was also the Minister for Justice and Constitutional Affairs, Makerere University Students Guild, Speaker at Makerere Law Society, Culture Minister when it mattered most in the hall, the mighty Mitchell Hall at Makerere University, a GRC Council Delegate at Mitchell Hall, and the Chairperson, St. Mary's Chitende Old Students Association. And last but not least, I have been reliably informed that he is also an Arsenal supporter. Ladies and gentlemen, please welcome with me Alex Luganda to speak to us. Yes, Alex. Yes, Alex. Oh, we are ready for you. Are you ready for us? Alex, no, we can't. Can you hear us?
I just want to confirm that I'm being heard.
Yes, you are being heard. Kindly proceed.
Thank you very much. And without any further ado, my apologies. I was supposed to be present with you physically, but I got some commitments that required me to travel, and I'm on road. However, I would like to thank Professor Mwevesa. Also tell him I'm his follower, keen follower, because he's been not only lecturing us on the political history, present, and the future of this country, but has been a very concerned citizen. On the forms of corruption is very, very important, because it is clearly telling us that most of the time the government efforts in dealing with corruption is treating the symptoms and not addressing the actual causes. My colleague Samuel Mulindwa has raised quite very pertinent issues on the question of political prisoners. And we are with him on a number of cases involving hundreds and thousands of Ugandans who are being prosecuted and persecuted because of their political beliefs and opinion. Because the concept of political prisoners is in line with persecution, or what is sometimes called prosecution, in line with what you believe in or do not believe in. The exercise of personal choice over a buffet of political opinion. And if I could take it on from where Samuel ended, over the last 20 years, we've had very spirited struggles by the state to secure a conviction on most of the political cases or on the political persecutions and prosecutions that have been engineered without any success. But the script appears to be changing. It's like currently, if we are to examine what is going on, the state is determined to get a conviction at all costs, including vulgarizing all known legal processes, precedent, procedures, and this has been done and is likely to be achieved with the total cohabitation and cohesion of some elements within the judiciary, which would be very unfortunate. Jura and the members, the other panelists, and the members who are listening to us, both within the Uganda Law Society house and online, I'll tell you this. If anybody had told the Right Honorable Anita Mong on the 1st of May this year that she would need to get permission for her to leave her residence in Nakasero to go to Bukedia, I am very sure Anita Mong would either laugh at you or would even order for your arrest for being very blasphemous on her right to movement. However, in less than 20 days after the 1st of May, the script has fundamentally changed. And what lesson is this to everybody? I don't want to talk about what happened to Kaihura. I don't want to talk about what happened to Jepam. I don't want to talk about all the other persons who were allegedly big figures until, as Professor Mwevesa has said, until their licenses were withdrawn. Until the political licenses were withdrawn. Now, to the lawyer who is out there and you're very comfortable, to the citizen that is out there and you're very comfortable, I just want to make this prophecy available to you that everyone, everybody in this country will have a test of the breakdown of the rule of law. The only question is, when will it reach your door? So we're only saying that be patient. You will test it. And when you test it, and when it comes on your door, then what the Uganda Law Society has been making noise about, what the Professor Mwevesas have been telling us over the last 30 years, what the civil society organizations and other right-thinking, morally cautious members of the society have been fighting for will make sense to you. At times, there is a likelihood of being misconstrued. For those that fight for protection of the rule of law, because injustice to one means injustice to everybody, are usually misconstrued as being anti-government. And when you start speaking and demanding for legitimacy, for protection of rights, you are labeled as anti-government. And that's the dilemma we even find the Uganda Law Society. Because for it to perform its statutory role as the rule of law watchdog, some members are labeling the Law Society as a political institution. Now, I will not repeat some of the issues that were raised by my brother Samuel about what exactly is going on. I remember when we were still in law school, we were being told that in criminal proceedings, the lawyer is accused number 2. Yeah, your client is accused number 1, the lawyer is accused number 2. Now, when it comes to prosecution of political related offenses or litigation, we as the lawyers involved in this are accused number 2 or sometimes co-accused. And just like Samuel has highlighted, even what happened to Lukwago, our senior brother Lukwago, in the court martial some time back, what happened to Aaron Kiza 1 year back, what has happened to all of us, because most of the time we do not come out to the public to speak out what pressures we are going through in engaging in these prosecutions. Be it at your law firms, you have a URA coming with sometimes obnoxious assessments. You have blackmails with the law councils here. They machinate clients at times to come and put you in fixes. There are issues of bribes. When bribes fail, they go to the stick. If you refuse to eat the carrot, they will bring the stick and intimidate you here and there. So, to bring it in context, and I would like to thank the Law Society, that maybe it is easier to bully. It is easier to bully us as individual lawyers who are involved in these processes of fighting for the rule of law. But when we have the demand for rule of law and respect for constitutionalism institutionalized, maybe it will help. Or if there is quorum, because we would like to have more and more lawyers. Samuel will tell you every time there is an arrest of either high profile political personnel over politically related charges, the first time we are appearing in court, you will have more lawyers than the sureties who are going to apply for bail. You'll have more lawyers than even the public that has come to attend court. But by the time we are having the third, after the bail is denied, by the time we are having the third, fourth, fifth hearing, the group of lawyers that was about 25 on record, you're remaining 5 or 3. And that tells you a lot. One, about our consistency and resilience as members of the profession fighting for the rule of law, or about our ability to withstand the trials, tribulations, and the challenges that are embedded within the practice around this area of political prisoners and political legislation, prosecution and persecution, sometimes as I want to refer to them. My brother Jurua and the members listening to us, I would like to say one thing, because Samuel talked about the concept of bail. Now, a few years ago, we had a move by the executive to amend the constitution in respect to the right to bail, in respect to Article 23 on personal liberty, in respect to components of Article 48 and the 48 hours rule. Now, that attempt to amend the Constitution was vigorously opposed by the public, by the civil society, and the executive cowardly abandoned it. However, ingenious, if I could say so, as they are, they went, sat with the legal advisor of the government, the Attorney General, sat with the Chief Justice, and now invented an amendment to the Constitution in what has been popularly referred to as the bail guidelines. Now, we who are in this practice of support to political prisoners, the bail guidelines have been given more pronouncement by the state and by the courts over and above the constitutional provisions. And I need not restate it, because I'm speaking to lawyers, I'm speaking to academicians, I'm speaking to Ugandans who know their constitution, because the 1994-95 process of promulgation of the constitution was done by the Ugandan Wananchi through the Constituent Assembly delegates. And then in that constitution, there is a provision that says the constitution is the supreme law of the land. And any other laws that are inconsistent with the constitution are null and void to their inconsistency. Now, you have the constitution in Article 23 highlighting and pronouncing the guarantee of the right to personal liberty. You have the constitution in Article 23, Clause 6, talking about issues of mandatory bail. And we are saying that the moment somebody charged for an offense which is not triable by the High Court has been on remand for 60 days, then the magistrate before whom such a person appears should release the person on their own cognizance. And the role of the magistrate is to set the conditions upon which the mandatory bail is granted. Now, what do we have happening in Uganda? We had legislation over this area of the mandatory bail in Foundation for Human Rights Initiative versus Attorney General, where the Constitutional Court came out and clearly provided guidance on the interpretation and the duty of the court in instances of mandatory bail. In attempting to draw a distinction between the court's exercise of discretion under the normal bail application and what exactly is supposed to happen under a mandatory bail scenario. But now when we are in courts, even where these political prisoners have been remanded beyond the mandatory period without commencement of trial, beyond 1 year, beyond 4 years, we have others in 7 years right now. The courts are hiding under the bail guidelines to violate the constitutional provisions. And to us, this is very, very absurd. It's one area that would need to give attention to. And maybe if I could also say, in respect to political prisoners, that the judiciary has been weaponized by the state. Judiciary has been weaponized by the state. And there is consistency. The cases that involve political prisoners are usually taken to the same courts. First of all, if you're going to look at the infrastructure and the ecosystem of the jail sector, they are taken usually to the same police stations. The investigating officers are usually the same. The magistrates, the judicial officers, the judges before whom they are allocated are the same. The prosecutors are usually the same. And the results of those processes, of the trials, of the bail application are also usually the same. And unfortunately, most of them vulgarize and bastardize the Constitution and the law. So where we are right now, the judiciary is a weapon that is being used by the executive for purposes of bringing to order and whipping all those who appear not to be ideologically perpendicular in reasoning and in ideology to the establishment or the powers that be as appertaining at the time. And I think that is one other issue that we need to look at. And maybe as I take leave, because the other issues have been properly highlighted by Samuel and Professor when they were making their introductory remarks, we have the issue of public interest. We have seen courts very often in these bail rulings saying bail has been denied in public interest. The nature of offenses are a threat to the public, so when we release in public interest, we are, and the state always parrot these arguments of public interest without coherent, cogent, and substantiated evidence. And then you hear the same being re-echoed by the judicial officers when they are denying bail, that in public interest. And I think it's high time we unpack this animal called public interest. Because when you look at some of the cases, the disclosures that are done, you get a total of 43 witness statements, police statements in the disclosure. And out of the 43, 37 have been statements that were recorded by police officers. Sergeant what, Corporal the other one, AIP the other one, IP the other one, SP the other one, ASP the other one, and then about 3 state operatives. Then you think, if this is an issue of great public importance, what is the public complaining? The complainants and the charade of witnesses that appear in these documentations you've done disclosure for are state operatives, state police fellas, security apparatus. Where is the public, and what exactly is the threat that we are talking about? Unless maybe we have to interpret it that possession of alternative political and ideological views is a state threat or a threat to the public, but that would also be a contravention of the rights to association, the right to assemble, and the Political Parties and Other Organizations Act that provides for a multiple buffet of political beliefs and ideologies within the country. And as I conclude, is the issue of disclosure, pre-trial disclosure, which has become a sticky issue lately, and sticking for no reason, because you're having instances where the state wants to ambush the defense in respect to the trial proceedings, because they're saying we cannot tell you identity of ABCD witnesses because we feel they're a threat. And then we're like, what exactly then is the threat? That threat cannot be unpacked. It is a blank statement thrown there. We have seen it in the Bestie trial. We are experiencing it in the trial of the before the unlawful drilling case that is ongoing in Kawempe Court, where I and Samuel are helping out our citizens in Noob, the Wisewas and the Edmonds and the others that are being charged. Now you want exactly how, and they tell you, no, we've not given you the details of these 6. These will come on the hearing day. And then we're saying, when do we now prepare? You as a state, you've had close to a year to prepare for this hearing, and now you want to introduce these witnesses in acronyms, in a hidden identity. They give evidence. Now, when will I do profile them? If I'm preparing the defense, when will I even understand the motive of their coming to testify? When will I conference with my witnesses, with my clients who are accused persons, among other things? And the other issue, as I finalize, is on the right to health and medical access. And we've seen this in a number of cases that we're handling with Samuel, where you have accused persons brought before court, and some even take plea when they are clearly limping. They have been tortured, they are physically distraught, mentally off, and then the judicial officers, the state, do not pay attention to their right to health, access to medical care as a first priority. Because the Constitution tells us they're innocent until proven guilty. But then when they're appearing in court, they are being treated by the judiciary and the state as condemned persons. We have had instances where accused persons have clocked the mandatory bail period. They are vomiting blood. On 3 occasions, we've had accused persons brought on cannula in ambulances from Luzira to court. And as soon as court is proceeding, because it's usually hot and all those other issues, they pass out. They have to be rushed for medical attention. And we have been always appealing to the court Do you want to have a dead body in court? If this person is sick and there has been no improvement, the medical facilities in the prisons will always say we can handle, but there has been consistency for a month. This person has appeared here every time is in this situation. Why can't you release them when they are being charged for offenses whose penalty is not death or life sentence? Even if it were, they are still presumed innocent. And finally, because we are on the media, I've been one of those people who have said it today to finally on about 4 areas. Every time I want to conclude, I'm remembering something. Is the access to media, public hearings, and access to media to these proceedings. We have had court give orders in some of the proceedings we are in. My brother Samuel may amplify him on that later, where the media has been gapped. They can't allow media to come and cover the proceedings because I don't know what exactly they want to hide inside there. So thank you very much. And I want to thank the Law Society. I want to thank my brother Semakade for steering and being resilient, and all of you, the support team at the Radical New, despite the challenges that you found yourself operating. Thank you very much, Yurua, and
Thank you. Thank you so much. Thank you so much, Advocate Alex Luganda, Owechtiwa, my speaker, and so many other things. Arsenal fan, thank you so much for standing with us and for your insights amidst your very busy schedule in your functions across in Busoga. You have managed to join us online to continue to help us appreciate the digital transformation that the Radical New Bar is all about. And we want to thank you so much for your insights. You have highlighted so many things. As you kept saying that you are concluding, you continued to remember 1 or 2 things. But yes, we appreciate, because these are things that have been really coming out of your emotion and where your heart has really been touched, because we chose you because also you have easily associated with the Kawepe Chief Magistrate Court matter that is holding one of the individuals that we are speaking about, Alex Waiswa Mufumbiro, the Deputy Speaker of the National Unity Platform, who has been detained for so long a time. And of course, you have easily identified with Advocate Samuel Muyizi, whom you've been crisscrossing in the courts of law, and you are clearly, as you said, one of the very few lawyers that remain standing tall after the case is and has been called for. Of course, the most obvious, the bail application. You say there has been more lawyers than the public for the first 1 or 2 hearings, and when bail has been denied, you eventually remain very few. So we want to applaud you for standing tall amidst the challenges and the persecution that you have termed as, where when you don't believe what the state imagines is supposed to be right, you are said to be antagonistic, especially in the last so long a time. For over 20 years, you have found it hard to find a political persecution matter concluded to its logical conclusion, because there is always 1 or 2 ways in which the state actually doesn't have any evidence but continues to circumvent around the process. As you said, the state has easily weaponized the judiciary, and the judicial officers have become the weapon. And that is really, really absurd, because those are our brothers and sisters and colleagues who we are supposed to be working together with as we ensure the rule of law is adhered to, and we are wondering what else we are going to do. But you have easily spoken viciously, as you have said, and identified with the Uganda Law Society, Professor who is here with us, the civil society, for continuing to fight and radicalize as much as possible the mindset, because if we don't do that, then who will? For posterity will judge us to have not done anything, especially when the bar association that you identify with, as the Uganda Law Society, being a watchdog, is said to be apolitical, even just because we are speaking. We have now become accused number 2 in criminal proceedings, and which is very, very absurd. We have identified members of the bar like Honorable Lukwago Elias Muyizi here with us, Alaka Caleb, Aaron Kiza, who, of course, the President, Semakade Isaac K. Senior Counsel, who have been through the mud waters when trying to protect members of society upon basic legal principles, which has only left the impunity to be seen to be overboard. You've identified with different aspects like access to media, which has always been denied, and you wonder what the media, the courts of judicature are trying to hide away from the public. The access to health, as you've seen, we have seen various political prisoners coming to court, having been tortured, coming to court with cannulas, and it's a very despicable scenario when looked at from the perspective of managing the constitution as the supreme law, even when the bail guidelines are now being used and being referred to more than the constitution. Every or majority of the magistrates or the judicial officers refer to the bail guidelines, whereas the lawyers continue to remind them, we don't even have to remind them, that the bail guidelines are a creature of the constitution. Why would you rely on bail guidelines when some things are apparent, the way Advocate Samuel Muyizi was saying, and the fact that the duty of pre-trial disclosure is being played around with and expecting to be surprised at court on the day, and yet you have had 1 year to serve us with this disclosure so as to prepare. You prefer for us to be looked at as unserious defense lawyers, and yet this is supposed to be an equal ground for us to lay out our issues and justice be seen to be served. So we want to thank you, Owechitiwa, Alex Luganda. You have so many hats. We appreciate you for the time you've given us, and we wish you the best. May the Lord continue to bless you. Thank you for standing tall, and we continue to identify with you as the radical new bar, and ask that the Lord will be with you in all your endeavors. Thank you so much, ladies and gentlemen. We were also joined by the council representative from the north, that is Advocate Emmanuel Omiat Egaru, who has joined us in the building, who is also a part of the Radical New Bar Governing Council. And these are the people that are blessing us with this platform and opportunity to reach out to the public, to ensure rule of law, access to justice, and access to information. As we get into the last individual that is going to help us speak a little more into the aspect or the case that is handling the defense team that is handling the Dr. Kiza Besije and Obeid Lutale matter that we all know about, has been a thorn in our skins, because this is something that Advocate Samuel Muyizi spoke about dating far back from 2005, and 2026 here we are still handling the same individual, and we want to wonder whether this is actually a legal matter or rather being a political prisoner. With me today is an advocate of the High Court, and he is a part of the legal defense team of the Dr. Kiza Besije and Obeid Lutale, individuals that are before the High Court. And we would like to request that you join me in welcoming Advocate Bayan Turinawe.
Okay, thank you so much. Firstly, I would want to render my appreciation to the Radical New Bar Governing Council for giving this opportunity and for contentious in our country at the time to be discussed. Secondly, I would want to issue my appreciation in joining my learned brother, Mr. Sam Muizi, to Prof for still being steadfast in this struggle for a just society, a just country, and history will remember you, Prof. Thank you so much. And maybe lastly, in my appreciation, I would like to appreciate the previous speakers for their participation in this specific discussion, but also their role as defense counsel in the matters of political prisoners. Maybe in context, political prisoners, any suspect who is arraigned before a court of law, it's the rule and the command of the Constitution and the construction of our legal system that the state becomes your prosecutor. So in essence, what it means is that all the resources of the state come and focus on only one specific person who is the accused person. Now, when the matter is even more political, all the tools of the state focus on that specific accused person. And the last bridge or the last shield of that specific accused person becomes defense counsel. And therefore, Mr. Sam Muizi and Mr. Alex Luganda, thank you so much for that specific role you're playing in our country. Back to the topic, which is the rule of law and political prisoners. I don't think I would do justice if I don't start by giving context or theoretical context to the meaning of rule of law and political prisoners. Firstly, it is, I think, one that we share and we know that universally, if we are to examine the concept, the rule of law, is that we must, that rules that govern the country, rules that govern individuals, one should be universally predictable, but they should also be written to safeguard arbitrary use of rules and tyranny by the state. Now, in that, we have core principles that are operative for the rule of law to gain its backbone. And specifically, we look at supremacy of the law, and that is to say that no person is above the law, including the president of the country. We look at equality before the law. Whereas the law is supreme, we should also be equal before the law. And lastly, fairness and transparency. In the historical context, and specifically ancient Greece, Aristotle, one of the philosophers, specifically distinguished between the rule of law and the rule of man. He argued that the rule of reason is vastly superior than arbitrary rule. So that specific philosopher was of the view that when he speaks about the rule of law, it is the rule of reason, because people have sat down, reasoned, and accepted specific principles and specific rules to govern them. So they have used their reason. The other part is the rule of man, which would not be something reasoned, but specifically people are making specific rules. In further enlightenment, philosophies like Montesquieu came up and said, no, we have to add more context, and even when that is the acceptable standard of the rule of law, there is something called separation of powers. We should separate powers of these state institutions. You cannot have an executive that is supreme. We should give roles, and therefore, after giving separation of powers to these institutions, we have checks and balances. The institutions specifically check themselves. And then we go to the modern theory of the 20th century of philosophers like Dicey, who now come and say that governments should not punish citizens merely by their own personal will, but acceptable rules and principles. When we examine all that, we have to also remember that there are two specific perspectives in application of the rule of law, and that is the formal procedure or conception and the substantive conception or the substantive part of the rule of law. What do we mean? We say that when we are talking about the formal conception, the way the law comes to be must matter. When we talk about the substantive conception, the way the law is what we examine. Why I'm bringing about those two specific things is because I cannot discuss the issue of political prisoners and rule of law without examining how laws come into play. Now, specifically, that's where I would want to start from. We know that the Supreme Court of the land nullified the UPDF Act, which was taking civilians to the military court. How the Parliament disregarded that specific decision, disregarded the public consultation, disregarded everything to reenact that law is enough questionable to show that government has become an abuser of the law. So we should not only look at the laws that exist and whether government is following them, but we also need to examine the issue of how the laws that exist come into existence. Having said that, it is important for us then to look at the laws that exist and how they are being applied. I will continuously refer to specific instances of, for example, the case that I was introduced to be handling, but I will make efforts to refer to specifically decided incidents or decisions so that I don't abuse the res sub judice rule. We agree that in Uganda, enforced disappearances have become something that is normal. We have individuals that we don't know where they are, we don't know whether they still exist, and no one is coming to aid questions that are being asked. There's a specific gentleman called Sam Mugumya. He was trying to join politics. I think he was contesting in Rukunjiri municipality for MP, and he was kidnapped. Of course, it's debatable because there is a statement that the state does not kidnap, but we agree that what they did in the circumstances is close to a kidnap. We don't know where he is. Now it is more than 6 months. Such enforced disappearances have been made normal. Now, to bring more context is that a habeas corpus application was made to the High Court Civil Division in light of that specific individual. And the state could only deny having knowledge of the whereabouts of Mr. Sam Mugumya. Up to now, the judicial officer that was an independent arbiter in that specific matter had only one thing to say, that the lawyers have not presented enough evidence to show that Mr. Sam Mugumya was kidnapped by the state. Yet an affidavit of the sister was on the record, an affidavit of the mother was on the record, saying how he had come into the country, and the state, it is the duty of the state to account for anyone who is in the country. So when a judicial officer comes and now says that it is the burden of the defense, it is the burden of the lawyers of such a suspect who has disappeared, we are left to wonder. Because such writs have been used since time immemorial. They are the writs that saved very many figures in Uganda, even in the times of dictatorship where there was no rule of law at all. Such writs helped the likes of Mr. Grace Binjira, RIP, and the famous ex parte Matovu case. So if such a writ that has been enforced in times of aggressive tyranny cannot help us in the 21st century, it's one to think about, and it's one to say that rule of law in this country has derailed. There is an aspect that has become a cancer within legal practice, and specifically in my representation of political prisoners, and that is the aspect of plea bargain. Plea bargain is that a person who has or who is suspected of commission of a crime comes and admits to that specific crime, and then the government, they negotiate the sentence between him and the government. Now, regrettably, because suspects have lost hope in the judicial system, and just like my learned brothers have already stated, Mr. Sam Wiza and Mr. Alex Uganda, remand has now become conviction. Remand is being used to punish more than even if you're convicted. So now suspects come because they know that if they plead again, they get out of prison easier than if they try to prove a case that they did not commit a crime they are charged with. I will give an example. Recently, there were people that were arrested before, they were arraigned before Uganda Chief Magistrate Court, and they were charged with, I think, an offense of nuisance, because an offense of nuisance carries a 1-year sentence after conviction in the maximum. Those specific individuals were remanded by the Chief Magistrate for 9 months before conviction. So, in essence, they served the sentence before they were even convicted. Sadly, they were later convicted, but it is to show you that remand time is now being used as a conviction or as a tool by the state to compel political prisoners to enter negotiations of plea bargain. And that's why probably we are even mooting, and we are about probably to reach out to you, the Law Society and the Radical New Bar, to offer us some assistance to sue Pepperdine and Norway for funding that specific plea bargain, because we don't think it's doing justice to the country and it's being abused. Courts martials have been talked about sufficiently, but we have to examine this specific thing called bail. Bail was formerly a tenet of our judicial, of our criminal law system. It was a right that, whereas it still exists, that you still have a right to apply for bail, it was something that was used by most political prisoners to seek refuge from the excessive power of the state. Now, to bring it to context, is that you have continuously referred to my client, Mr. Chiza Besigye, who has continuously been or interacted with the criminal justice system. I need to remind you that in 2005, long before I started even practicing law, Mr. Chiza Besigye was a beneficiary of something not in our statute books, and that is called interim bail. In our jurisprudence at the moment, we have something called bail. Interim bail is not something that is within our statute books. But at the time in 2005, because our judicial system was still one that was strong, Mr. Chiza Besigye, having applied for bail, was released on interim bail before opening, hearing an application for substantive bail. That is how much he has the best antecedents to receive bail in this country. But a judicial officer tells you that in 2026, a person who benefited from interim bail cannot benefit from mandatory bail, which is a constitutional command. How sad and how fast this country has moved in the 21st century. And when you're examining that specific decision of the High Court, you might forget the selective application, the bail guidelines. When Mr. Chiza Besigye was before the Chief Magistrate Court of Nakawa, he applied for mandatory bail. And the claim was that he has spent more than 180 days on remand. Now, the Chief Magistrate at the time made a decision and stated that that is only something that can be investigated by the High Court according to the bail guidelines. But the same bail guidelines are the ones that introduced an aspect that if you are arraigned before a chief magistrate and you spend more than 180 days on remand, the magistrate court must forward your file to the High Court for that specific question of mandatory bail to be explored. And you're quoting the same guidelines after 180 days, saying that you should go to the High Court instead of forwarding my file to the High Court. Rather unfair, but we said it's okay, and we made that application before the High Court. The details of that decision, which is in public fora, is understood because the trial judge was of the view that Dr. Chiza Besigye has never appeared before the military court martials, which was strange. But even before having a say about the decision of mandatory bail in that case, there is a decision of Justice Kania on discretionary bail. I'm discussing these decisions because they have been decided and the rule of res sub judice does not hold me. Mr. Chiza Besigye and Obed Rutale make an application for ordinary bail. The judge in her ruling agrees that they fit the test for being admitted on bail. The judge agrees that they have fulfilled all terms of bail. But the judge says that no, they cannot be released on bail because treason is the greatest of great offenses in our statute books. We appreciate the Radical New Bar because we saw a statement in opposition of that specific decision, which we thought was selective application of the tenets or principles of a right to bail. But even as we examine that specific interaction with the judicial system, it is important to reflect on the continuous excesses of the state. It's important to reflect on the continuous commentaries of the fountain of honor of the state on that specific case. We all know that the fountain of honor has had a lot to say about the case, but more notably, you remember that months ago, the political party and family of Dr. Chiza Besigye organized prayers, and the president himself, as reported by the Archbishop of the Catholic Church of Uganda, called or sent a message and stated that they should be postponed and they will be given another date after his clearance, just praying for a political prisoner. We all know that up to now, the prayers have not been held because that clearance has never been given. So the question is, if the state, through the president himself, not even by delegation, through the president himself, can interfere or intermeddle with just prayers, what about the right of Dr. Besigye to bail? If the president thinks that he should first clear the citizens to pray for an individual citizen with rights not granted or guaranteed by the state, rights which are inherent under Article 4, anchoring from the Bill of Rights, that to be prayed for you in absentia, it should be cleared by the state, and it's a threat to security. What about his right to bail? What about his right to a fair and speedy trial? And that is why throughout the whole case, there has been an attempt to ensure a speedy trial for our clients. And what we keep fighting for is that the command of the Constitution does not say that an accused person is entitled to a speedy trial. The command of the Constitution is that an accused person is entitled to a fair and speedy trial. So because fair and speedy should be two sides of the coin. If you give me a fair trial, which is not speedy, then you have abused the command. And if you give a speedy trial, which is not fair, you have abused the right of an accused person. And therefore, we keep pushing for a fair and speedy trial. Mr. Alex Luganda brought an aspect that I would want to comment about, but rather restrained by the rule of sub judice, which is the abuse of disclosure, which is one of the tenets of our criminal justice system, that a person who is accused should know the case against him with full material implicating him or exonerating him. That specific command actually states that you should be given material that the state is going to rely on, that implicates you in commission of the offense. But you should also be given material that the state discovered in the investigation that exonerates you from the offense, if there is any. But that specific right is continuously being abused by the state. And I wish that when the witness protection application, which we are specifically arguing in the Dr. Chiza Besigye and Rutali case, is decided, we come back here to discuss the dangers it would have posed if it's dismissed, or the dangers it will be posing if it's granted. With that, I would want to keep thanking everyone, the audience, and to keep imploring us to continue putting a brick on the rule of law in the country and continuously push for the rights of political prisoners, because they are really under threat. They are really and really under threat. Thank you, and have a good afternoon.
Thank you. Thank you so much, Bayan, for that elaborate discussion of the topic. You have taken us back to history, which of course is perspective and context, as you said. Very important aspect, because obviously the speakers before you had also done justice, but you did not rest at that. You helped us to give perspective, especially to the general public. Of course, this is an educative session. We are here to help each other to appreciate the matters that touch the law and affect the public. So yes, Bayan, you have been all hands on deck. Thank you so much for breaking it down, and thank you for your continued resilience with standing with Dr. Kize Besigye and Obeid Lutale for the things that you're doing. Cannot be done by so many. Clearly, you're not so many on that defense team, and easily it can be seen that you really do so much, because we keep watching what happens to these cases, and we keep to wonder how the lawyers in personal contact these matters, as you are, Alex, yourself, and senior lawyer Sam Muizi, and you have easily given us education about the history, the rule of law, and the components, the principles, supremacy of the law, equality before the law, and fairness and transparency. And that, of course, is supposed to already set the pace on how the members of the public, especially those that are not lawyers, but also for purposes of learning, it is also okay to be reminded about what the rule of law, which all of us stand for, especially the department that handles these sessions at the Uganda Law Society, for which I am a member, a proud member at that, with my superior over here in the building, that we should continue to appreciate what rule of law is, and we always have to be reminded. You have easily helped us pick out a few topics, including the aspect of bail, and how Dr. Kiza Besigye was the author and the beginning of and being a beneficiary of entering bail, and yet he can fail to be a beneficiary of mandatory bail. And you ask questions of how fast the country is going, and we're asking whether the country is going backward or forward, because this is 2005, and in 2026 he cannot be accorded mandatory bail, and yet you are also identifying as you have given us with the discretionary bail that was the ruling from Justice Kanya, in which he had met all the requirements. That was one of the most shocking rulings. Even the Omuntu wa Wansi was very shocked. Nobody needed to have appreciated law to understand that kind of ruling being double-sided. You have fulfilled all the terms and conditions as court would require, but we can't release you because of actually what Alex had said, public interest. There was something like public interest. There was treason being the greatest opinion, public opinion. It was her opinion. She gave the ruling in her own opinion, not as per the law, which of course easily leaves us wondering about the selective application of justice, the aspect of fair hearing, whether it is fair when fast or fast and not fair. We had a recent case of Okello Onyum, which was a first hearing, and the state said you wanted a first hearing. It was within, is it a week or two? A week or two, and you're asking, now you're asking for, what are you asking for? You wanted a first hearing. So we're asking, is it fair? Was it fair? These are so many questions that we're asking ourselves, and we have been honored to have experts to help us unpack these issues. We chose to specifically identify with the defense team of these different cases, which are very, very apolitical, and easily it is evident that the three lawyers who were before us, as the previous speakers, have been crisscrossing within themselves to handle the same matters, because they are all under one theme of political prisoners. We'd like so much once again for your time, your wisdom, your deliberations as the Uganda Law Society. Without speaking on behalf of the members who are here before me, who are my bosses, the governing council, I would like to thank you for according us with this very, very respectable time and opportunity to learn from you, both the professor and the defense team of the different political prisoners, bringing into perspective these two topics regarding public accountability, political accountability, and political prisoners. We have come to the close of this function, but before we go, obviously, we would like to, one, request that you lend us a few minutes of your time, because there's some questions that have been coming in. I know the professor is very, very eager to answer the questions, but his topic has easily been intertwined with political prisoners, because it's very hard to separate them. And we have a question from Mr. Agwai Ambrose. Mr. Agwai, thank you so much for asking that question, and would like to ensure that you get answers to the question, because that is the reason that you are attending, to understand and maybe get more information. And you are asking, do you believe Uganda applies justice equally regardless of political affiliation? That is to the professor. We would like now to be specific, because the topics have been very much alike. So we would like to use the opportunity to request you to give your general perspective and also your parting shots to that regard. But he also asks, maybe for you, Mr. Professor, to sum it up. He asks, what reforms would you propose to strengthen judicial independence and public trust? I think those two can be married together. What reforms would you propose to strengthen judicial independence and public trust? Professor, you could use the microphone before you by switching it on, that gray button. Thank you.
Thank you, the audience, and thank you for being attentive, so that we can have a conversation about these issues to see whether we can shift the ground. First of all, I'm saying shifting the ground in the context that here we are talking about law, the written law, but there is an unwritten law, which is norms. There is written law and unwritten law. So even the unwritten law, which is norms, is as important as a written law. So, unless and until the ground is shifted from forces of privilege to forces of social justice, and forces of social justice with social justice norms, with social justice orientation, with social justice values, the written law will be manipulated. Instead of having rules of the games to govern our society, we shall be having games in the law. We shall be having games in the rule, not rule of law, not rule of law and having rules to govern society, but we shall have rules to protect privilege. So we need to work hard to shift the ground, to shift the norms, to have norms of social justice overcome norms of privilege and privileged forces. So when you see the parliament has been captured by privileged forces, you get the pedigree of those who have gone to parliament. When you have our Politburo, the SEC, has been captured by forces of privileged forces, then if the ground doesn't shift to social justice forces, the law will just be played around. We shall have just games in the rule rather than having rules that govern society. So legal approach to these issues, like even the corruption I was talking about this morning, I am not dismissing it, the legal approach, but we need to have political approach. Most of these challenges we have, whether it is rigging elections, whether it is subverting justice, are political issues fundamentally, primarily, and secondarily, they are legal issues. So you lawyers, excuse me, lawyers should have that angle, you should have that perspective of looking at law from a political perspective. It is not purely about justice and legal gymnastics. It is about also having politics of the law. So when you ask about how we can avoid the selective application of justice, we cannot determine it by legal means. It has to be political means. Selective justice is now the order of the day. As I said earlier on, this morning, about the license. Corruption is licensed until the license is revoked. That is why people are forgiven, because they are good mobilizers. They turn a blind eye to those who are good mobilizers, and they go and capture those who are small fish. That has something to do with the norms of society, the political norms. So justice, selective justice will continue unless the ground shifts from privileged forces to social justice forces. So the reforms the questionnaire was asking is not basically transforming society legally, it is transforming the political norms. Because I don't think that we lack the laws. The laws are there. Generally, the Constitution is there. I think somehow progressive, although it could be improved. But the issue is shifting our normative framework, not the legal framework. No. I think maybe I am exaggerating. We need both legal framework to shift and the normative framework to shift. But what will shift the legal framework is the normative framework. So we need to push and have critical masses, a critical mass of people with social justice norms, with even in the academia, by the way. I think we have a challenge, in my opinion, that we have an intellectual tradition of privileged people, of privileges. Mwana wani, mwana wa gundi, yeah? Ndiwa class. You know, the privileged classes have taken over the political discourse and have taken over the political space instead of having social justice forces. So the question is political. The question is not basically legal. Whether it is the electoral commission, because now we have an electoral commission, we cannot change that, what the outcome of that electoral commission until the ground shifts politically. So issues of corruption, issues of whatever, need a political approach, a critical mass. So lawyers, please, in this, you can have all the fine laws you are talking about. You can do that unless we have got the right norms for preventive. Let's use again the analogy of medicine and apply it to, say, accountability and corruption. Is that we need preventive measures more than curative measures. Not the legal aspects that we are going to try cases in the court, we are going to arrest people. No, we need more of preventive measures so that there is a political price when you practice nepotism, cronism, favoritism, and the like, that there is a political price. However, today, people are not paying a political price. The more you steal from government, the more you are cheered. That is why in Rwengo, people cheered Chinyabatama and Anita Mong when they said, when you steal from government and bring some crumbs to the people, is okay, people cheered. But if people had picked grass and thrown it in their eyes, that kind of reckless statement would not have appeared again. So the solution is normative reforms, political thinking. And I call upon everybody here to think about political reform so that people pay a price. Otherwise, we shall have rules of the game. Instead of having rules of the game, we are going to continue having games in the rules and suspending. Do you know the parliament is now full of suspending? You know this chief whip with his deep voice. What is this young man? Amson Obua. He goes to parliament and feels very big and, Madam Speaker, let's now suspend Rule 175, Clause B, and it is hereby suspended. Now, suspension has become the rule rather than the exception.
They gave me the rules.
And he gets out and he goes in a car and with this front, the car in front and another one behind, you know, and people admire. That is where we get it wrong. Suspending rules is now a rule rather than exception. Suspending rules was supposed to be whatever. So we have licensed corruption. We have selective application of the law. I will end by showing you an example of selective application of law as I normally give when I get opportunity in the public space. The case of candidate Narkora and Nambi in Kawempe. On a Thursday, the Electoral Commission had said that, had instructed that nobody should hold a rally before they meet the Electoral Commission, which was supposed to be, I think, on a Friday, on a Saturday, the meeting. So on a Thursday, Narkora breaks that rule. And you saw how he was pulled from border, pulled down. His rally was stopped. The following day, why I'm remembering it, I happened to take that direction of Gayaza Road. We were stopped all the way from Kubin because Nambi was on the road with a wheel loader, escorted by police and taken to Kawempe grounds, Kawempe Mosque ground, Mbogo grounds, where Narkora wanted to be the previous day. The Electoral Commission officials were around, police was around, SFC was around, UPDF was around, everybody was around. Nambi held Harare peacefully and went home. That is selective application of the law. The previous day, Narkora was molested and tortured. The next day, Nambi was escorted and protected in broad daylight. And those who are in charge of the electoral management kept there in industrial area with their coats, hiding their poverty in big coats and suits and talking good English. When your law was broken, somebody was punished. When your law was broken, somebody was protected. That is selective application of law. That cannot be cured in the courts of law. It has to be cured in the field of politics. That is how, I don't know whether he satisfied his curiosity.
Yes, without a doubt, you have actually done more service to it than expected. Thank you so much, Professor. That has been a very good and broad answer. Mr. Agwai Ambrose, I believe you have received your answer and would like to very fast move into the next few questions so that we can use the next few minutes, maybe 10, to answer these. Mr. Alex Luganda, are you still with us?
Yes, I am.
Yes, thank you. We have a question from a namesake of yours called Alex Kaja. I want to believe he also comes from your area. That's why he specifically sent it to you. He is asking, Alex, thank you so for your question. He's asking, what role should the civil society, legal fraternity, and the media play in strengthening accountability? What role should the civil society, legal fraternity, and the media play in strengthening accountability? He also doubles it by asking, what reforms are urgently needed to restore confidence in Uganda's criminal justice system? I hope you've had the questions, and if you could marry them and give us a few highlights into this, and also give your parting shots so that we could release you to go back into your schedules. Thank you.
Thanks very much, Jura, and my namesake, plus the members of the panel. I think the question raised are two, but they're not related. Although, one, what can the civil society, what can the law society do? I think the civil society is still doing what it's supposed to do, because it is advocacy, it is bringing up suits and lawsuits, either in the constitutional court or in the other lower courts, for purposes of protection of the rule of law and enforcement of human rights. The only challenge is that right now, as we speak, before the civil society, for example, has to fight for the citizens, the civil society has to fight for itself to survive. Because if you're to appreciate the legislation and the move of government in the recent past, it is intended to stifle civic space, right from the abolition of certain subjects of the curriculum being taught in schools, because those kinds of education material will awaken civil awakeness and responsibility of the citizenry, to gagging media space for for the civil societies and the law society, to stringent financial and regulatory conscriptions. Every time we are going into an election cycle, in the 2021 election cycle, most of the civil society organizations and the NGOs that were dealing in the areas of civic space, democracy, governance, rule of law, justice and law order sector were rounded up. Over 60% of them had to close shop and left the country. And the same thing has happened. Right now, all these new concepts of the Sovereignty Act and all these are intended to limit the space. So in answering your question, Alex, my namesake, is that what can the civil society do? Because the civil society right now is fighting for its own survival. Ordinarily, they would be coming to fight for us, but they have done what they had to do in the circumstances. For the areas of the criminal justice system, what can be done to make it better? I think for me, the problem may not even be necessarily the absence of a sufficient reforms or legal infrastructure. It is there, but the will to respect the law and implement it as it is. Because yes, we have certain areas that need redress in the criminal justice system. That can be a full discussion that we can have with the Radical Nuba organizing a webinar for the same. But for me, my actual issue and concern is that there must be respect for the existing laws, because we can't talk about further reforms when the few and the basics that are outrightly clear are not being respected by the powers that be. And finally, to echo the words of Justice Uganda Ntende in his farewell remarks, the question still is to team judiciary: where are the Chitios? Where are the Wamzis? Where are you to stand? When you're a judicial officer, you take an oath. When you're a judicial officer, your appointment is not a political appointment like Fanara DC. You are appointed through the Judicial Service Commission, where you go through due process. And if you take a decision and one is not happy with it, they have remedies of appeal, a review, revision, administrative interventions. So why can't you stand and be protected by the law? Because you have the law in your hands. Then you run to take decisions that bastardize the profession, that vulgarize the bench, and make all of us a laughter. I made a statement recently when I was in one of the courts, in one of the bail applications, because we had agreed we are no longer going to quote the law. It is not important to quote cases when we are in court, because the principles of stare decisis that we studied or precedent are no longer important. You quote the law that are equally binding and are still good law on court, and the decision will be delivered, which has not even considered any of the decisions of the Supreme Court, of the Constitutional Court, which you gave on that particular subject matter. And neither has the judge or the magistrate given reasons why they have not, or why they have departed from the binding decision that you have presented to court. So I was joking that at times we are being mocked by the students, the young lawyers we taught, and those we are still teaching in universities on some of the legal principles we teach them. They keep asking us, are these things you teach us theoretical or they are for legal practice? Because we saw you in court last time, you were saying all the things, and then the decision was like, that doesn't matter. So for me, as I take leave, and I thank all of you, thanks to the Law Society. What should the civil society do? They should do what we are doing now, because the Law Society is doing this, and we are adding our bricks to the process for the rule of law. Thank you very much.
Thank you so much, oh Uganda, as they say, Team Judiciary, where the kitchels and where the worm is. Thank you so much, Alex, for that breakdown and unpacking. We bless you through the name of the Lord and ask that you will continue to do what you're doing and continue advocating for the rule of law. A question for Mr. Muyizi from Nasasira Aida. Nasasira Aida, thank you so much. We have a question. Is there legal clarity in Uganda on who qualifies as a political prisoner since you have been one? Is there legal clarity in Uganda on who qualifies as a political prisoner since you have been one? And also the question that what implications when opposition figures repeatedly face terrorism, treason, or security-related charges. What implications arise when opposition figures repeatedly face terrorism, treason, or security-related charges? Could you kindly handle those two questions in the shortest time possible? I know it's difficult, but you would also help us to give your parting shot. Conclude.
Indeed, they are quite wide in the remaining time, but at least most of them have been answered if you followed. Political prisoner is someone who is imprisoned because of their alternative views from the status quo. We've discussed selective application. So selective sanctioning of charges. Charges many are sanctioned by the DPP based on your political orientation. The larger picture is what we discussed here on selective application of justice, where we continue having the kings. You know, when we are with the professors here, you continue learning. But to put it in proper perspective, we have the law which applies selectively or differently when it comes to those in power, those we would call the kings, and the servitudes or the servants. And the way the laws are being amended progressively, I think says a lot in this direction. That brings in perspective on the decision on what you would be charged with. You found a Mwanga Chivumbi, whose people were killed, whose agents were killed, murdered in cold blood. People had come as his agents, people who had come, even those who had come to cook porridge for his agents were murdered. Majority of those who were killed actually were women. And then a charge of terrorism. Instead of investigating the murders, he slapped with a charge of terrorism. So that is what describes what a political charge would be. And to answer on whether the law in the Nalukola case was solved the issue, it is again in the negative, because as counsel in that matter, actually the violence meted by the state was again, you know, they commit violence just like in Mwanga Chivumbi, violence against you, and they use it against you. In Nalukola, it was violence against him where the state participated in destroying electoral materials, and then the courts used that very violence to favor the state's candidate. So that is, I think, what explains how the law is applied selectively against politicians. So it's selective application of justice between those who are in power and those who are trying to change things in the administration of justice in this country. There are a few things you cannot forget. That, like he stated, that mandatory bail ceases being mandatory when it is about political prisoners. You'll find that in other matters, people just put up their hands and state that I've spent on remand a given number of days. We all know as lawyers that all those people have been released on mandatory bail. Selectively, politicians, if it's a politician arguing mandatory bail, then it ceases being mandatory. I think that explains and puts it in perspective. It's selective application of justice right from the arrests, prosecutions, and determination on for how long you can stay on remand and your matter is not handled. And you remember, these are the lacunas that had the intention of mandatory bail was to ensure a speedy trial. You fail to prosecute a person as fast as it should be. But even upon failing to prosecute someone, cannot even afford them at least the mandatory bail that is provided for under the law. So I think that would explain to someone there what we term as political persecution rather than prosecution.
Thank you so much for that answer. That's even clearer. I hope Ida and all the others that are listening in and watching on the other platforms are benefiting. This is what we intend to bring to you. Lastly, we have a question, 2 questions for Bayan from Orishaba Kevin, but I think you answered one of them. What is the true meaning of the rule of law in a constitutional democracy? But I think we answered that one ably in your presentation. The other question to you is, at what point does prolonged remand become a human rights issue? At what point does prolonged remand become a human rights issue? That is for Bayan. I would kindly request you to give it a minute or 2 so that we can wind up with this session. Thank you.
Okay, thank you so much. Okay, thank you. The issue of is not per se. Okay, thank you. The issue of prolonged remand is not per se a human rights issue because there is no specific abuse of human rights. When you examine our Human Rights Enforcement Act and all the rights therein under our specific constitution, you can clearly see that if you have seen a court of law, then you are now handed over to the rules of engagement. The rules of engagement include remand. Now, how we can just stretch it is on the right to a speedy trial. Because if you are entitled to a speedy trial under the Constitution as one of your rights, and that trial is being delayed by continuous remand, that's how we can stretch it to become a human rights issue. But per se in itself alone, it's something that the judiciary or the state might do in some circumstances and get away with it because the remand is an aspect of procedure. It's a procedure of handling criminal cases. So the only attempt that we can have as advocates to litigate upon that and successfully say that it's a human rights issue is on the delayed trial, because you are entitled to a speedy trial. So if you're continuously remanded, we can make a case for you for your right of a speedy trial being abused. Yes.
Thank you so much, Advocate Bayan. We have come to a close. Or yes, yes, Professor, please. Is it on?
I hope it is on.
Yes, it is.
Thank you. I want here to state something and agreeing with President Museveni. Recently, there was a statement trending, which he made some time back. And he was, in that statement, he was saying that law can be double-edged. It's a double-edged sword. A law can be used to promote justice, or it can be used to subvert justice. Law can be used to subvert justice or promote justice. And here you have been talking about jurisprudence. I don't know what you study in the law school, because I'm not a lawyer, and the jurisprudence you do there, but I don't know why our judicial system and judicial officers here do not use to promote justice, do not use it to overcome privileged statuses and positions, and promote justice. So I want to leave you, those who want to go and read here a reference. There is something called critical jurisprudence. It is a branch of knowledge, critical jurisprudence. It is about law promoting emancipation as opposed to law promoting controlling people. So go and read critical jurisprudence and see how to apply it in our judicial system. I thank you.
Thank you so much.
On that,
Yes, Mr. Muizi.
actually, as I said, decisions are being made retrogressively. Where we had good decisions on bail, current judges actually are making decisions which are really taking away the good jurisprudence that we had. I've participated in a matter, you remember the Nalwa case?
Yes, in Masaka.
Where a magistrate said he can now create a new
You
precedent.
can make new law.
Make new law against the decisions. So even the doctrine of precedent, like Comrade Uganda said, we are suffering as a team. Actually, if you recall, some of you, when one of the judges was brought in Masaka, and I realized by me appearing before him in the same case would end up overturning decisions or being retrogressive.
Yes.
I did not want to participate in a matter where the very precedent we made before the judges like Chibuka Musoke in the Winnie Byanyima cases was going to be now washed away by these new cadre judges. So the problem we have now in matters of precedent are contract judges, which is unlawful. Someone is on contract today, he's listening to a matter where a president has made a pronouncement, and that decision is supposed to be against that very president who has to confirm the contract. That is one of the problems now we are facing with the president, and that is how we had some of us sometimes now are even running away from courts, which is bizarre. So you want us to participate, but sometimes it is even better for us to run away from some of these judges so as not to take us back. My parting shot, very last one, gratitude to the Honorable Semakade. So, you know, I have two presidents who are performing so well while in exile. President Semakade has really shown that now the digital age, you can be the best performing president even when you are not in the country. Yeah. I believe if he was here, he would not be serving us as well as he is doing.
True.
Right now, because those impediments, blockades are not there. The second one is the Honorable Robert Chagulanyi Sentamu. I know for a fact that his diary now, without impediments, wherever he is more busy than, and he's more active than he would have been in the country, thanks to the digital age. But again, no one would want to be in exile, and no one would want to see a country where a president swears in,
when all his opponents are either in exile or in prison as political prisoners. I thank you.
Thank you so much. As we come to the close of today's engagement, we would like to sincerely extend our gratitude and appreciation to our distinguished panelists, the members of the press, the colleagues from the legal fraternity, the civil society actors, the students, and every Ugandan who has followed us for this conversation with keen interest and a little bit of patriotism that we hope can be built on every other day. Of course, today's discussion has been to the fore. We have come to know that public office is not merely a position of authority, it is rather a sacred public trust, and these individuals before us today have done that discussion justice, and all we have to say today is really thank you so much, because the rule of law must protect both the state and the citizen, otherwise it will be the rule by law, as was said by Advocate Bayan. We therefore want to leave this session, of course, with the collective responsibility to defend constitutionalism, as the Uganda Law Society has always been saying and doing as well, including such aspects of accountability and public outreach, to demand for accountability without fear and favor the way Professor has viciously spoken, and to uphold judicial independence, as Advocate Alex, who has joined us online, just like gratitude has been given to both Presidents Robert Chagulanyi and Isaac K. Semaka, the Senior Counsel for the Digital Age. Thank you so much, Alex, for joining us amidst your very busy schedule. So the Uganda Law Society, in a very special way, would like to thank you, but I am not a better person to say that in the presence of the council representative from the North, who we are going to welcome to the podium to give his closing remarks, as well as thank you on behalf of the Governing Council. Thank you so much once again.
Okay, thank you very much, our moderator of the day. Well done. You have performed exceedingly well, and as usual, may God continue to give you the energy that you have. My name is Emmanuel Egaro Omiat. I represent the lawyers of Northern Uganda. My job right now is just to move a vote of thank you to you, our panelists, and I must say, as a Governing Council, on behalf of our President and my colleagues, members of the Governing Council, we are very honored to have you today speak to the nation through Radical Uganda Live series. This is the 15th Radical Uganda Live session of 2026. I really don't have much to say, but in a special way, let me begin by thanking you, Professor, for sparing time. We are so honored to have you here, and you spoke with so much passion, experience, and wealth of knowledge. You have asked us to look at the problem as a political one. In your own words, you said the problem is not only legal, but political in nature, and so we should ponder about that. You said the question is political, not only legal per se. And so we should be looking at the political angle, as well as we address these challenges legally. You also said that whereas these issues are legal, but consider a political approach. I think I take it as really a wonderful advice and word of wisdom. You ask us to consider preventive measures. Still, you are making emphasis on us considering, looking at the other side of the coin. And you said instead of rule of the game, what is having now rule in the game. What we have now is the game. Games in there. This is very, very interesting. And so it is it's laughable, but at the same time it's sad when we, talk about some of these things. We really need to ponder about all this that you have told us. A colleague of mine added that whereas we look at it as a political question, maybe we also consider prayers. I think all these are words of desperation. But Professor, once again, thank you very much. Continue to, have time to talk to us, to talk to the nation. And may God continue to bless you as you continue to address some of these injustices in the society. To my colleagues, Defense Council, you have done us so well by sparing time and coming here. Very critical issues that you have passionately addressed, and we want to thank you for the courage you are having. It has become very risky in Uganda right now, actually, to represent political prisoners or to represent, Ugandans who need our services. Without the courage, the kind of courage you have, it's very, very difficult. I also know that courage is the ability. The definition of courage is that courage is the ability to hide fear. Continue to hide fear. And to show courage, continue to represent our vulnerable people, especially the political prisoners. And as Uganda Law Society, we shall always be there to work with you, to support you in seeing that justice is attained or justice prevails. People who deserve justice indeed get justice. Professors asked us to read about critical jurisprudence. Yeah, we are going to do. As for me, I think I'll take time to ensure, because it has become a big problem. Actually, even when you're in court and you have the young lawyers, even without you citing authorities in court, the judicial officers themselves will tell you, you are wasting our time. Just state what you want to state. It has become so sad. And so the question of jurisprudence, courts following these precedents, which are already set, my colleague there, you correctly observe that most of these new judicial officers are on contract. And so they are not there to serve the citizens of this country, but to serve the appointing authority, which is very, very sad. Ladies and gentlemen, on that note, I want to thank all of us who participated today, the staff at Uganda Law Society and the Department of Rule of Law, and all the staff who participated, members of the Fourth Estate, all the participants, those who are here, and even those who are online. We want to thank you so much for sparing time, for participating, for listening. And we want to wish you the very best of the day and of the week. Thank you very much. I say this for God and my country.
Thank you. Thank you, Elde Garu. We would like to request us to have a group picture over here, as it is a culture after we've had these sessions. Adam will guide us so that we can have this for the record. Thank you so much. You're kindly welcome here. Miss Afra, please.